First of all, Secretary of State, can I congratulate you on behalf of the whole committee on your appointment and welcome you to your first appearance before us. Mr. Robbins, welcome back. As you both might suspect, we have a great deal of ground to cover, so succinct questions, colleagues, and succinct answers would help. Firstly, Secretary of State, to you, when will the committee receive the results of the Irish joint mapping exercise?
I'm conscious that my predecessor did write to you about that. That is something I'm looking into at the moment, so I can't give you a precise date, but I am very aware of that issue and I'm keen that we get an answer to you as soon as possible. Right.
Can I just point out, it was your predecessor but one. It was in April, and your predecessor but one said to us we'd get a copy of it shortly. Now, I don't know what your definition of shortly is, but December is not my idea of shortly, and I think the purpose in asking the question is, are we going to see it before we vote on the 11th of December?
So I'm alive to the issue, as I say.
I know you've been
in post just over 2 weeks, made inquiries on it, and I will get a letter to you shortly to update, but I'm very conscious of the issue.
But then, could you explain to us what might possibly get in the way of your honouring the commitment of your predecessor but one to the committee, i.e. not releasing it to us?
Well, as I say, I'm very keen, and we've seen through various motions in Parliament that Parliament can request information anyway. So, as I say, I'm very keen to get the information to you, and I hope to have an update on that shortly.
Have you had any resistance on the EU side to this now being published? Are you aware of any, either yourself or Mr. Robbins? Anyone aware that this is a problem? No. Sorry?
I would have to clarify on that point, Mr.
So you don't know, neither of you have any idea whether there's a problem on the EU side to publishing this? Because the argument was, while the negotiations are going on, okay, but they're finished now, so we ought to be able to have it. And a promise is a promise.
Which is why I'm hopeful we can get something to you shortly.
I would say on behalf of the committee, the clear expectation is we're going to get it, and that when we get a letter from you, that will make it clear. That's helpful as long as we see it. Now, as I understand it, Secretary of State, you'll be leading principally on domestic preparations for Brexit. Is that correct?
Well, it's two things, Mr. Benn. So I think firstly on the domestic side, there's obviously, as you're well aware, a huge amount to do, both in terms of the forthcoming meaningful vote, in terms of the planning following that with the withdrawal agreement bill, with the various plans that will need to be done in terms of legislation, or in the event of that vote not going through in terms of no deal planning. So the first aspect is on the domestic side. Secondly, in terms of the phase 2, which perhaps is the crux of your question. On the phase 2, then I will be leading that politically on behalf of the Prime Minister. So ministerially, I will lead that on behalf of the Prime Minister in terms of phase 2. And in terms of the structure of Whitehall, that is an issue that I am discussing with the Prime Minister and with colleagues across Whitehall, because, as I'm sure you will appreciate, as we move into phase 2, then the governance structure will undoubtedly need to reflect the different approach. Obviously, there's going to be a lot of different work streams, and indeed, just the mere fact that we will be outside the EU institutions, so the Prime Minister's own interaction outside of those institutions will change. So that is something that we are looking at, and I'll very happily write to you and the committee once we have further clarity on that.
That would be extremely helpful, but on the assumption that Michel Barnier is still sitting on the other side of the table, he's going to find you sitting looking at him. Well, when it comes to those negotiations.
Well, as I said, two things. So firstly, in terms of ministerially, I will be leading
that's what I mean.
On the phase 2. In terms of the governance, the architecture within Whitehall, that is something that we're looking at the moment.
Fine. Can I take it you've seen the legal advice of the Attorney General on the withdrawal agreement and the political declaration?
Yes, I have.
You have read it. Could you just briefly explain why is the government not complying with the resolution of the House of Commons of the 13th of November?
Well, I think the Attorney General, as you know, is before the House this afternoon. I think the House and the committee will have ample opportunity to explore that with him. As you know from your own distinguished ministerial service, that there are well-established conventions in terms of legal advice. Those arguments, I understand, were also rehearsed at the recent liaison committee, of which You were a member through your role chairing this committee, but I'm sure the House will be discussing that with the Attorney-General this afternoon.
The reason I'm asking you, I'm of course well aware the Attorney-General is appearing before the House later, is if the government is saying that this clear resolution of the House of Commons, which the Speaker has confirmed, is effective, it's not just an expression of the opinion of the House, it is an expression of the will of the House that certain documents should be provided for it. It does have implications for certain other votes that are coming up if the government is going to say, well, that was all very interesting, but we're not doing it. And really, I'm looking, I think, for reassurance that if the House of Commons votes for certain things to happen, which may well follow the result of the vote on the 11th of December, that the government is going to respect that and get on with it rather than saying, no, we're not doing it. It's a point about democracy in the House of Commons.
I very much hear, Mr Benn, the point you raise. I'm always mindful myself of the Speaker and the directions that he gives. But it is an issue, as I say, the Attorney will address this afternoon. And I think it's best that, as the law officers lead on this, that they allow the Attorney-General to address it.
But do you think, in general, that if the House of Commons votes and tells the government to do something, that the government should do it, as a general principle? Is that something you would subscribe to?
I think there's distinguished members of the committee. I look at Mr Chope particularly on this in terms of standing orders and how the House rules. As a general principle, when the House makes a direction, then obviously the government listens very carefully to that. But at the same time, it is also a point of long-standing practice that legal advice, for very well-known reasons of which you're well aware, which is if legal advice is disclosed, then there is a concern as to how that might impact in the future on the frankness and openness of legal advice. It's a very well established approach that legal advice is not published, but the law officer this afternoon will discuss this in more detail.
Okay, well, we look forward to hearing further later. And finally, to you, before I turn to Mr Robbins, why won't the government rule out no deal, given, first of all, it's quite clear we're not ready as a country, and secondly, given the documents that were published last week, it would do considerable damage to our economy?
Well, I'd rather put it as in we're ruling in a deal. We have a good deal that respects the referendum result. European colleagues have made it clear it's the only deal. It delivers on things such as a skills-based immigration system, taking us out of the fishing, being an independent coastal state, taking us out of common agricultural policy, things that I, as a Brexiteer, campaigned for, so it delivers on the referendum result. But it does so in a way that, as the Chancellor has said recently, that also manages our economic relationship with Europe, ensures we have the free flow of goods. So we have a deal on the table, which is a good deal. It's the only deal, and that is what, as a government, we should be focused on delivering.
Well, that's very helpful. Unfortunately, it's not the answer to the question that I put to you. The question I put to you is, why won't the government rule out leaving with no deal, given, in my view, we're not ready, and given the view of the government, as published last week, that it would do damage to our economy, and you've heard what businesses have said about the implications of leaving with no deal. How could any responsible government contemplate leaving with no deal?
Well, in your previous question to me, you said, Mr Benn, that the government should be always mindful of the resolutions of the House. The point that was there, and therefore for the government to rule things out, one can't be certain, because the point, if we don't support the deal the Prime Minister has secured, and secured after a very hard-fought negotiation lasting over 2 years, where the Prime Minister fought day and night to secure a good deal for this country, a deal that honours the referendum. The point is, if we don't deliver on that, then we risk significant uncertainty, and as the Prime Minister has set out, that could be no deal, it could be no Brexit. I'm sure members of the committee reflecting different perspectives on the referendum will explore both sides of that. But the point is, we will move into uncharted waters, we will move into significant uncertainty, and that could be no deal, but it could also be no Brexit, and that's the risk. And both of those options, that uncertainty, will be very damaging for the jobs of your constituents, the jobs of my constituents, and that's why this deal is the right deal for us.
Well, indeed. I suppose, let me ask you one more time. Would you personally support leaving the European Union with no deal?
Well, we're preparing for no deal. There's significant work going on.
We know you're preparing, but is it something that you, as the Secretary of State for exiting the European Union, would be prepared to support, to leave
Well, what I support, Mr Benn, is the deal that the Prime Minister has negotiated, and that is what we are focused on. But one cannot second guess, and your earlier question on the legal advice pointed to this very issue. One cannot second guess how the House will react. But it's the government's focus to deliver on this deal because, as a number of senior European figures have made clear, this is the only deal, and it is a deal that the business community support. It gives them the certainty they need for jobs, but it is also one that doesn't damage our democracy, because not honouring the referendum, the biggest vote in our history, I think will be hugely damaging for our democracy and be very divisive for the country.
Well, I hear clearly what you say. I would also just observe the job of government is to prepare for all eventualities, and
we are preparing.
You are preparing for a no deal exit. Now, Mr. Robbins, can I just turn to you? Can I begin by expressing appreciation to you and all of your civil service colleagues for the very hard work that you've put in over the last 2.5 years to these into these negotiations in what I think it would be fair to describe as quite challenging circumstances. So if you could convey those thanks on behalf of the committee, we'd appreciate it.
Thank you.
Do you think the customs backstop is a bad outcome for the UK, and if so, why?
I think that the backstop is not the future relationship that either the UK or the EU wants to have with one another. And so it is an uncomfortable position for both sides. And the reality, as you know, I think, Chair, in evidence from us, but also in your meetings in Brussels, is that there is not a withdrawal agreement without a backstop. That reflects, of course, also, as I've said to this committee before, Ministers' commitments to Northern Ireland and to avoid a hard border on the island of Ireland, rather than being something imposed upon us. So it is a necessity, and a slightly uncomfortable necessity for both sides.
Okay. In what way would it put our security cooperation at risk if it came into being?
So the provisions of the Northern Ireland Protocol do not extend current security cooperation. Everything that we want to do as partners for the European Union on the security front is in the political declaration, and I think ministers are pleased and satisfied with where that has come out, but none of that is automatically conveyed by the legal text of the Northern Ireland Protocol.
Okay. Can you tell us what the impact would be on trade between GB and the EU if we were to enter the backstop? What kind of friction would be involved? That wouldn't apply to Northern Ireland, but it would to GB-EU trade. So could you tell us what that friction would be?
I can't precisely, Chair, no, because that would depend upon a whole series of other factors, including explicitly the level of alignment and regulatory cooperation between Great Britain and the EU in those circumstances.
But how would that be determined? Because we could be facing having to take a decision on whether to enter the backstop, within a year and a half's time? The choice between, do we go for the backstop, do we go for an extension of the transition period? Are you saying that you would expect that something would be worked out that would add to what we already know about the backstop between now and then? Because we've had evidence that says there would be some friction, because obviously the GB would be in a different place from Northern Ireland.
So all I'm saying, Mr. Chairman, is that there is no presumption in the backstop of fluid trade between Great Britain and the European Union. What the text says is that the degree of regulatory cooperation between the United Kingdom as a whole and the European Union will, of course, be a factor in the way both parties decide how to set their systems of checks and controls. So nothing is assumed in either direction.
Why doesn't the word frictionless, which used to be the government's policy, frictionless trade, appear in the political declaration? Is it because we didn't ask, or the EU wouldn't agree to it?
So the government has put forward its proposals on how to achieve frictionless trade with the EU, as you know, vociferously, especially since the White Paper in July. And as I think the Prime Minister briefed you at the Liaison Committee last week, some of those proposals have gained traction, others are still challenging and difficult. I think what ministers were pleased about is that the political direction that's laid out in the declaration makes clear that it's the ambition of both sides to achieve as frictionless a relationship as possible, and that at the extreme, frictionlessness is not ruled out by the spectrum of outcomes that's described in that declaration. Okay. But I don't think ministers, least of all the Prime Minister, are hiding from the fact that we've still got a job to do to convince people of the detail of every bit of that.
I think the key in the deal is it will be a sovereign choice, and throughout the negotiations, the Prime Minister was told it was a binary choice. It was a choice between Canada or a choice between Norway. And I think what the political declaration makes clear is actually she has secured a bespoke relationship which gives a spectrum. So there is a choice between frictionless and alignment, but that is then a sovereign choice as part of that negotiation.
And finally, from me, when it comes to services, because I've asked you about goods, but when it comes to services under the backstop, if it kicks in, then, for example, British broadcasters can currently broadcast to all member states with a single licence. Would that come to an end if the backstop came into operation? It's a factual question.
Would you like me to take that, Secretary of State? The protocol only relates to those aspects of EU law that are required in order to avoid a border in Northern Ireland. So that's about tangible goods. It says nothing about services. So if the backstop were to apply in the absence of any other agreement with the European Union, there would be no services relationship.
So there'd be no services relationship, so the broadcasters couldn't do that anymore. Mutual recognition of qualifications for architects and lawyers, the current arrangements would come to an end. So any arrangement that our services sector, which is 80% of the British economy, 80%, would come to an end under the backstop. But that is correct, is it?
So a whole series of relationships in both directions between the EU and the UK, in the absence of any other agreement, are not catered for by the protocol, which is why it is an uncomfortable situation for both sides.
But then the government in its Chequers proposals never asked for anything on services. That was the whole point. So I think it's a bit hard to blame the backstop for the fact that it won't cover services, because the government didn't ask for services when it came out, the Chequers proposal came out in the summer. I think that is correct, is it not?
Well, may I answer
that,
Secretary of State? I don't think that's completely fair, Mr. Chairman. I mean, the political declaration, I think, remembering the hours that we spent discussing it, is clear about the level of ambition on both sides on services, and says explicitly that it wants those service relationships to be well in excess of the arrangements standard under WTO arrangements, and indeed go beyond those agreed in recent EU FTAs. So already, like in other aspects of the political declaration, the EU side is agreeing with us that this should not be a standard third country relationship.
I do acknowledge that point. The point I was merely making, that it's not covered by the backstop, which could kick in. Anyway, that's very helpful. Stephen Crabb.
Thank you, Chairman. Good afternoon. Can I stay on the subject of the Northern Ireland backstop, because I think it's probably one of the most problematic areas within the withdrawal agreement. And can I start, Secretary of State, by asking you, are there any provisions of that backstop protocol that you have concerns with, or are you wholly comfortable with the way that it's drafted?
Well, there are compromises. I think with any negotiation, Mr. Crabb, there are compromises.
No, but concerns that you have. What would be the specific concerns that you have about the way the current backstop is drafted?
Well, I think the first point I make is the intention is not to go into the backstop. So there's a number of safeguards, one of which is the option to avoid going into the backstop. There's also things like, for example, extending the interim period, implementation period. There's also safeguards in terms of coming out of the backstop, in terms of the best endeavours, the requirement for the timetabling, the option in terms of technology, which was specific language that was put into the political declaration. And then, as Mr. Robbins has just set out, actually the backstop is very uncomfortable for both sides, because, for example, if you take fishing, on the fishery side, the EU 27 would lose all access under the backstop to our coastal waters. So there's safeguards in terms of the front end of the backstop, the safeguards at the back end of the backstop in terms of coming out, and there's a mutual interest in not retaining, not being stuck in the backstop. And that's reflected, for example, in Part 5 of the political declaration that sets a time frame. So there's a mutual desire on both sides not to be in it. But in terms of the areas that are less appealing of it, obviously there will be, I think, 92 pages of rules where there would be alignment. and obviously one would have preferred not to have required those 92 pages. But the reason for those 92 pages, we should be clear, the reason for the backstop is because it is unique within the United Kingdom in terms of the land border and in terms of the history, in terms of the peace settlement. And that is why the special bespoke circumstances have been arranged. But there is a common desire on both sides not to get into the backstop, and certainly for it not to become a permanent feature. And I think a lot of colleagues have been concerned around the question as to whether we would get out of the backstop. And as I say, there are 3 tiers of safeguards to avoid that happening.
So is it your view that the best endeavours clause and the fact that you believe that both sides will be heavily incentivised to avoid going into the backstop is enough to make colleagues in the House swallow what I think you would admit is an uncomfortable wording of the way the EU can veto us unilaterally leaving?
Well, I think we need to make the case because I think it is actually quite a complicated area of law. I think the legal wiring between the withdrawal agreement and the political declaration takes some unravelling. And I think sometimes people reacted very quickly to the withdrawal agreement, and actually and I think there's a good opportunity with the Attorney General today, as one gets a clearer picture of that legal wiring, one gets a better understanding of the obligations it places onto the EU. And I simply point out, for example, some colleagues were concerned when the Prime Minister, in the joint report in December, made the commitment of the backstop because they said it was binding. Well, the same applies in terms of political declaration. It might not be legally binding, but politically it would be very difficult for the European Union to row back from the commitments they've given. And part of the reason I think the negotiation for Mr Robbins and his team has been so difficult is because the European Union take that language seriously. I think if it wasn't meaningful, if they didn't need to rely on it, they perhaps would have been more relaxed as to actually what went in the text. And I think the reason that has been so hard fought is because it is a negotiating instruction to both sides, and therefore will have a significant impact in shaping the Phase 2 discussions. But I absolutely accept that a lot of colleagues across the House have been concerned in terms of the ability to come out of the backstop, and that is something we need to explain. Thank you,
Secretary of State. Can I ask, therefore, to Mr Robbins, the Times recently reported that you and your team had drafted a termination clause for the backstop, which included a specific unilateral mechanism that would allow the UK to quit the backstop if it so desired. Were those reports correct?
Ministers asked us to look at a whole range of options for how to bring the backstop to an end, and so we did. And the Prime Minister and other ministers tested some of those out on European partners. But what we went into the negotiation with in the end was a text that delivered the termination clause very much as it's laid out there.
Did the text of the termination clause that the Times reported on, did that ever go to Cabinet for consideration?
I don't think it, if I may say so, I think I should allow myself to be governed by the normal convention. I don't talk about what's gone to Cabinet or not. All I can certainly assure you, as I hope the Secretary of State will back me up, is that ministers have had advice on the full range of options, and what was tabled in the end was a ministerial decision.
But you said a moment ago that it was tested on European counterparts, so presumably we can infer from that they pushed back pretty strongly on that draft of a termination clause with a unilateral mechanism.
Well, I think what's always been clear is there can't be a deal without a backstop, whichever, and we may come on to the other deals that colleagues have been exploring, but I think a very clear narrative. Obviously, I've only been at 2 cabinets, so I wouldn't have been at the cabinet where that may or may not have been discussed. But the point is, what has always been clear is that whichever deal is entered into, there will need to be a backstop. So whether it's Canada, whether it's Norway, whether it's EA+, the various options colleagues have floated, they would always need a backstop.
Can I ask you then, Secretary of State, when the deal gets voted down a week tomorrow, will you be advising the Prime Minister to resurrect Mr Robbins's draft termination clause with the unilateral mechanism to take to the summit the following weekend to ask EU EU leaders to reopen the text of the withdrawal agreement and insert such a termination clause?
Well, firstly, it's the government's intention to win that vote. That is what we're focusing on. You would expect me to say that, Mr. Crabb, but that is the case. And I think as minds are focused on the uncertainty of the alternatives, and we may get into a wider discussion of those uncertainties and whether those other options would themselves command a majority of the House, then it is very clear that the only deal is the Prime Minister's deal. Yes, there's some compromises in that. That's the reflection of a hard-fought negotiation. But that is the deal, and that's the deal we need to secure.
Thank you very much.
Thank you very much indeed. Emma Reynolds.
Thank you. Good afternoon. If the UK and the EU do enter into the backstop, can you confirm that under the withdrawal agreement that the UK government cannot unilaterally withdraw from the backstop, and actually that decision would have to be taken by the joint committee as referred to in the withdrawal agreement, which is made up of representatives of each side?
So you're correct that it would be a question for the joint committee and then the arbitration process, and that's a normal approach. The point about that is, again, the idea that the EU has some sort of veto on that process is not correct, because there are requirements in terms of, on both sides, to act in good faith going through that. And any interpretations of law, because, again, a question that's been raised is, well, what would the role of the European courts be in that process? The role of the courts is not to determine. The role of the courts is simply in terms of any interpretation of EU law. So the role of the courts is regarding the factual position, what is the interpretation of the law, not determining the case. So it would be for the joint committee, the arbitration process, and there are requirements in terms of acting in good faith as to how that would need to be conducted.
I understand what you're saying, but so it is the case that the UK government couldn't withdraw from the backstop unilaterally. That's certainly the case.
Because it's an insurance. I mean, the whole nature of the backstop is an insurance. But as we've already covered, Ms Reynolds, there's strong incentives, firstly, to avoid going into the backstop, but secondly, as to why, from a EU perspective, they themselves would not want to stay. And if indeed you look at the comments that President Macron raised the other day, the point about those comments relating to fishing is that on day one, the EU 27 would lose access to UK coastal waters under the backstop. Now, that would be a difficult conversation, I'm sure, for EU leaders to have with their own fleets. That is a further indication of their desire not to remain in the backstop. And indeed, the political declaration reflects that, because it also gives a clear timetable in Part 5 to incentivise those discussions.
I hear what you're saying, but the factor going in the other direction is obviously that the need to avoid a hard border on the island of Ireland. And my question really is, the backstop could become quite long-term if the EU and the UK cannot find a solution to that problem. If you cannot come to an agreement that avoids that hard border, then the backstop will remain in place.
I don't think so, because it's a key issue, and it's one that a number of people, I think, have been concerned about. So firstly, it would be difficult from a European perspective if there was any suggestion of permanence, not least because Article 50 doesn't allow a permanent relationship. So the very nature of that would open up litigation risk for firms in the EU 27 who would feel that Northern Ireland business, in having the best of both worlds, would have a trade advantage compared to firms within the EU 27. So it might be the case that this committee would take the view that the willingness of the European courts to react to Her Majesty's government would be limited. But what I think is much more reasonable to conclude is that the European courts would react to, for example, a French firm that felt it had a trade disadvantage compared to a firm that was able to access the single market without the UK paying any lump sum in terms of its fees, without being subject to the full freedoms in terms of freedom of movement. And that's why, if one looks at the media reports, some in Europe have criticised the backstop. I know it seems odd in the context of the UK political debate, But some in Europe have criticised the backstop because they feel that Mr Robbins has got an advantage in the negotiation, and the Prime Minister's got an advantage because it gives access to that market without the financial contribution and without freedom of movement. That's another reason why it's not an advantageous position for the EU. And I give a third.
But there could be friction. Let's just be clear about that. There could be friction, and we've taken evidence on this, between the UK and the EU, and Mr Robbins has just conceded that this is the case depending on regulatory decisions on regulatory equivalence. But the situation with regard to Northern Ireland and the rest of the EU is different to that with regard to the UK and the EU. Isn't that the case under the backstop? So what you're talking about is actually access for the Northern Irish economy to the rest of the EU, not the whole of the UK.
Well, there's already different aspects to this. So if you take animals, for example, there's 5 million animals flow to and from across the Northern Irish border as it is. If you look at the moment between the GB and Northern Ireland border, there's around 30 checks, particularly around animals at the moment. So there are already existing issues there. So some of these points are already in place.
Okay, sorry, one last question, but on the future relationship. Mr Robbins, you were there in Salzburg, as I understand it. Given the response from EU leaders at Salzburg, particularly to the economic proposals in the Chequers plan, to what extent do the economic proposals in the Chequers plan still constitute the UK's negotiating position on the future relationship? The response being negative, just to be clear.
Thank you, Ms Reynolds. I mean, firstly, of course, the response to the white paper at Salzburg and before and after it has not been perhaps as wholly negative as some have portrayed it, including on the economic side. And I think if we had time to go through the whole declaration, there are many aspects of our white paper proposals which are welcomed and reflected in where the joint declaration has ended up. I think, it's for Secretary of State to speak for the government's policy as we enter into the next phase, but what I can say with confidence is that the position that the government took in the white paper, this declaration allows us to continue to argue for that in the areas where we have not yet nailed it down.
And can I ask why, given that is totally uncertain, I mean, I'm just to echo what the Chair said, thank you and your colleagues in the Civil Service for all the work that you've put into these many documents. I know you've been hard at it for years, not weeks or months. But it is the case that the political declaration is not legally binding. Therefore, it's still unclear whether our future economic relationship will look more like the EU's economic relationship with Canada or Norway. That's still not clear. Because the negotiations really only just begun on the future relationship. Is that the case?
May I have a first go at that, Secretary of State? So just one thing I think the Secretary of State's already mentioned, but let me just amplify it a bit. It is not a legally binding document, the political declaration. That's of course true, Ms Reynolds, but it's extremely unusual, I think unprecedented in my experience, for a political declaration like this to be explicitly referred to in an article of an international treaty. And so in Article 132 of the withdrawal agreement there is, no, I've got my numbering wrong, it changed. 184. There is...
in the previous draft it was 132 of them.
We added 50-odd articles. The 184 is the one that specifies that the declaration dated as this declaration is the basis then for the negotiators to proceed. So that is, as Secretary of State was saying earlier, that's not just a moral commitment and a political commitment, but actually a failure to proceed in good faith with the decisions taken in that declaration would be ultimately something that's internationally enforceable. The second thing is that I think I would say that this declaration does give actors in the UK and the EU a great deal more confidence than they would have had before its signature. For a start, some of the basics of the economic relationship that were in doubt until we had achieved this declaration are now certain. There shall be no tariffs, no fees, no quantitative restrictions, a whole series of things which in a standard third country relationship would not be there are declared as not going to be part of our future economic relationship. And I think it's fair to say, European officials have said this for their side. Once the Union makes an offer like this, it's very, very hard for it to step back from it. And I think one of the achievements ministers should be justly proud of over the last few months is that in its March guidelines, the European Union attached a long list of conditions to such a close economic relationship. Some of those, frankly, were a bit extravagant, and what this declaration does is it pares those down to a much more common sense level. There are some areas, particularly in regulatory cooperation on goods, where the true extent of how far we can manage away some of the checks and controls and frictions that might be part of a standard economic relationship is not yet fully bottomed out. But the key achievement in this document is that that is still to play for in the second phase of negotiations, and indeed in mentioning the spectrum of outcomes in the way the European Union has jointly signed up to doing, it concedes of there being a relationship between the kind of obligations the UK and the EU are freely going to enter into with one another and the degree of friction in the trading relationship. So as the Secretary of State said a moment ago, basically both sides have agreed this is not quite the binary situation that some made it out to be some time ago, where you're either Norway or Canada, if you forgive the caricature.
Okay. Thank you very much. Jacob Rees-Mogg.
Thank you, Mr. Robbins, can I first ask you about today's Daily Telegraph and a couple of extremely interesting comments that are attributed to, which you may wish to dissociate yourself from, and I at least want to give you that opportunity. First of all, he, that is to say you, argued that extending the transition period after Brexit would provide a more cast-iron escape route. Is that your view?
You'll expect me to say, Mr. Rees-Mogg, that I'm not going to comment on an apparently leaked document, but it is certainly true that if the UK were to enter into an extension to the implementation period, some of the other negative consequences of being in the backstop that the chairman referred to at the beginning would not apply.
Thank you. Now, I thought you'd say you wouldn't comment on a leaked document, so I'll ask again whether it's your view on the next quotation, regardless of where it's come from. We should not forget that the backstop would, even with a UK-EU customs union, is a bad outcome with regulatory controls needed somewhere between GB and NI, serious and visible frictions and processes between GB and the EU, and no security cooperation provided for. Is that broadly your view?
All I can do is reiterate, Mr. Rees-Mogg, that the backstop is definitely an uncomfortable outcome for both sides.
Well, at least for one side. Thank you.
I think for both, Mr. Rees-Mogg.
Well, I'm not at all convinced about that they've got us exactly where they want us. And Secretary, can I come to you now, because you mentioned that this would only be temporary. But temporary in EU terms can be quite a long time, can't it? Norway remained in a temporary agreement before the EEA was established for 22 years. So when the government says temporary, that's not a time-limited temporary.
Well, you're correct that people can take different interpretations, Mr. Rees-Mogg, of temporary. The point is, what are the incentives? And what I alluded to earlier was, would the EU27 be comfortable with losing all access to our coastal waters on day one of a backstop? I don't think they would. I think that would be politically difficult. Would they be comfortable with the fact that businesses would have access to the single market without the vast sums that you and I campaigned against, without the freedom of movement? I don't think they would. Would they be comfortable with the litigation risk of firms claiming a trade distortion? Would they be comfortable with the potential disruption to their own future free trade agreements as they try and calculate those without having clarity as to what the population size on which those free trade agreements? So it is not perfect for either side, and if one doesn't, because I can see from your reaction, accept any of those safeguards, there is also, and this followed the work of a number of colleagues in government, a clear language in the political declaration in terms of things like the use of technology to expedite a solution. Because actually what we're really debating here is a huge focus on with the withdrawal agreement, which is the winding down element, and the backstop is a part of that. But the key opportunity for us is the future trade agreement. That is the way we get out, well, we try and avoid going into the backstop in the first place. But if that were to arise, and there's ways of avoiding it with the implementation period, but if it were to arise, the key is to move into the future trading relationship.
Your point, Secretary of State, on the backstop being so attractive for them, surely is slightly contradicted by your suggestion earlier that no deal was possible without a backstop. If it's so bad, why did the EU insist upon it?
Because the EU cannot enter into a permanent relationship whilst we are still a member. and therefore we need to have exited in order to reach that future agreement. Now, one of the issues, which I'm sure you and I have, well, if I may just finish the point, please. One of the issues I'm sure as Brexiteers you and I have often been lobbied about from business is they don't want two sets of changes. They want to have one change. Now, if you come out on a no-deal situation with the World Trade basis, then one assumes one is also looking in the future for a free trading arrangement. Well, you are then into having more than one change. One of the attractions of the Prime Minister's deal, through having the implementation period, is not only do we give businesses greater certainty in the short term, up to the end of 2020, but then beyond that, when a change is made based on that future arrangement, it is done because we have left at the end of March.
But that assumes that no changes are made in the UK ex-Northern Ireland post the implementation period under the backstop, because you're saying that there would only be the one change, and therefore you're saying that the backstop would not allow GB to use its flexibility to change regulations.
No, what I'm saying is
there will be two changes, it doesn't exist.
What I'm saying is what I hear all the time from business is they want certainty, they want as much clarity as possible. In Parliament we have had over the last week or so a huge focus on the withdrawal agreement and on the backstop. In essence, the winding down provisions of our relationship. What needs to be the focus and what the Phase 2 discussions are about and what the mandate that is set out in the political declaration unlocks is actually the future relationship. And it is slightly paradoxical that we've had all this fixation on the backstop and the withdrawal and the winding down provision when actually as a Brexiteer, as an optimist for the future, as someone who wants to trade with the globe and actually look to the wider world, what we should be looking at is that future trading relationship.
There's an inherent contradiction, isn't there, in saying that the EU couldn't use the facility under Article 50 to negotiate the future framework, that it can have a backstop without an end date, but it can't go further than that. It seems to be the EU can agree what it feels like.
No, I don't accept that. I think one of the features, and I always feel this whenever I read the European Union, the correspondence that particularly write on the European Union, what is always striking is how much their approach is informed by the legal process. And I think sometimes that's something we don't give sufficient weight to within the UK. And it is the legal process in Europe that a permanent relationship, a permanent trade arrangement cannot be reached until we have left. I am committed to ensuring, and the Prime Minister is committed to ensuring that we do deliver on that. We do leave the EU on the 31st of March, and by that point we're then in a position to be able to agree a trade agreement. But we can't do that before we have left.
It's not quite what your predecessor but one said. He said the trade agreement could be agreed a nanosecond after we'd left. It couldn't be formally agreed, but it could be negotiated.
Well, actually, I think, with respect, Mr. Rees-Mogg, you're splitting hairs there, because the point I was making was you can't agree it until we've left. The point you have just said is it couldn't be agreed until we're left. Well, one can argue as to how quickly after leaving it can be agreed, but the point of law, as a former lawyer, the point of law still stands. The legal point, and I come back to the point that the EU takes a very much an approach, as I understand it, where its legal process is very important to it. And the point is you cannot agree as a matter of law, European law, until we've left. That's the point.
The history of the EU is that it's managed to adjust its legal process whenever it's needed to in other cases.
Well, the law does evolve, of course.
Of course, and when it needed to bail out Greece, it suddenly found that laws didn't apply at all. But let's come to some specific points of Annex 2, Article 3, subsection 2. The United Kingdom will apply to its customs tariff may not, under any circumstances, which is lower than the common customs tariff for any good or import from any third country. When previously has the UK allowed for taxation without representation? Because the EU will be setting our customs taxes, and we will have no say on it once we've left.
You're talking in terms of the Northern Ireland Protocol?
No, this is under the backstop. Annex 2, Article 3, subsection 2. Taxation without representation.
Well, I don't accept that at all. I haven't got that precise text in front, so I'll pick that up and happily write to you on it. But we've covered why the backstop is undesirable, we've covered why we have no desire to go into it, and we've covered the safeguards that there are in order to allow us to exit from it.
But if the EU raises tariffs, we will have to follow, and we will have no vote on that at all. So it is taxation without representation, a fundamental constitutional principle given away in the backstop.
No, I don't accept that at all.
Okay, but you don't seem to know about it, which is a bit of a problem. Can we go also then to Article 174, disputes raising questions of union law, because the government has consistently said that the jurisdiction of the ECJ will no longer apply once we have left, with the exception of citizens' rights. But this says that the arbitration panel shall not decide on any such question. In such case, it shall request the Court of Justice of the European Union to give a ruling on the question. This is not discretionary, this is absolute. But when you look at some of the things that will be included in the backstop, for Northern Ireland, specified EU law on VAT and excise, environment, electricity markets and state aid apply to the UK in respect to Northern Ireland with backstop, and they will all be subject to the jurisdiction of the European Court of Justice. Can you explain how this squares with the government's stated view that we will be out of jurisdiction of the ECJ?
So I think there's a limited area in terms of Northern Ireland. So the single electricity market is distinct anyway. Firstly, that was a bilateral agreement before. So that was a bilateral agreement entered between Ireland, the Republic of Ireland, and the UK. So that wasn't actually done through the Commission, and there's very good reasons.
Under the ECJ.
It will.
Yes. So that's an addition to ECJ jurisdiction, rather than a subtraction in this agreement.
So there are, again, it comes back to my earlier point in terms of winding up issues. So there are, in terms of, this applies also to goods, which I think was inherent in your question, which is there are certain areas, the same actually applies in terms of citizens, where as part of the winding down arrangements, there are certain rights in place, certain arrangements in place, which are currently within the jurisdiction of the European Court. And that will continue within the backstop. I've touched already on the desire to come out of the backstop. But within Europe itself, VAT is not harmonised. There are variances within Europe. So VAT is not something that is static across. What European law says on VAT is it's around the minimum rate rather than the constant rate. So in the backstop, Northern Ireland would have to maintain the minimum VAT, which goes to the debate, for example, one sees in the press on things such as the tampon tax and whether that could be changed. So there is an issue in terms of Northern Ireland in terms of the minimum rate, but the UK obviously can align with that. So that's from a unionist point of view. That doesn't mean there's a distinction. But I think it would be misleading to suggest there is one VAT rate across Europe, because actually it's the minimum bit, not the harmonised bit.
I didn't begin to imply that, but you mentioned the tampon tax. That couldn't be removed in Northern Ireland under this, nor could VAT on domestic fuel be removed in Northern Ireland, and the European Court of Justice would adjudicate on that. That is all correct.
Well, we said, in terms of the...
Because I just need to be the last part. Okay, I've got one final point after that. On that issue, the European Court will be ruling when the government has said we'll be out of jurisdiction of the court. So when the government says things, are we to assume that there is a footnote saying except in certain circumstances? Because the government doesn't particularly footnote its comments. And my one final point is bring your attention to Article 4. Because Article 4 is at the heart of this, because it establishes this treaty as superior law and requires that inconsistent or incompatible domestic provisions may be disapplied. So the suggestion that some members of the government could make, that if we don't like the backstop in the end, we can simply pull out of it, we would then be breaking domestic law, because we have agreed that this treaty should have the same status, the unusual constitutional status, of the European treaties.
I mean, well, we will, and Parliament will get a very good opportunity to debate this in terms of the withdrawal, the WAB, in terms of the bill that is coming forward. But in terms of how that applies, you're correct in that there will be a direct effect element to those provisions, and so there will be, in essence, a reach into the bill. The bill will give direct effect to that element, but it is a very limited element, and it really goes to the heart of my reply to Mr. Crabb, which is there have been some limited compromises within this. But what matters here is the bigger picture. The specific circumstances of Northern Ireland have required some compromises, both because of the land border and because of the history in terms of the Northern Ireland peace and the Good Friday Peace Agreement. But that is very limited in its scope. Some of those actually predate, such as the single electricity market, actually predate this and were done on a bilateral basis. Some of it relates to the common travel area and how that interrelates. So there are bespoke issues in terms of Northern Ireland. Now, one can take a very purist approach and say that none of those compromises should be entered into. One shouldn't have arrangements distinct to the Northern Ireland situation. But I think actually what's probably, rather than my comments on this, if you look at the views of the business community in Northern Ireland, if you look at the views of the Ulster Farming Union, if you look at the biggest manufacturer in Northern Ireland, Bombardier, and the head of the Belfast plant, what you hear consistently from the business community in Northern Ireland is, yes, there have been some compromises. Yes, there are some very limited areas, very limited, and we can all sort of play at sort of picking out individual bits of law where the courts have a reach. But actually the bigger picture here is this is a deal the business community in Northern Ireland support. This is a deal that the farming community, the farming union, the Ulster farmers support. And that is because they see the benefits, and indeed the same benefits that some in the EU 27 are concerned that businesses in Northern Ireland will have the best of both worlds. And that's why they support it.
Thank you very much.
Do need to move on. Peter Bowden wanted to come on this issue. Yeah.
Going back to something the Secretary of State said, he referred to the implementation period. We were told clearly by the Prime Minister on many occasions that the implementation period would be time limited, and it was an implementation period, not a transition period, so that the time that the implementation period was agreed, we would know what we were implementing. And one of the reasons she said that is she said she didn't believe Parliament or the British people would put up with £39 billion of their money being given to the EU without the knowledge of what was to come. And I think she slapped down any minister who called it a transition period. And she also said, Chairman, that nothing is agreed till everything's agreed. And Mr Barnier said, by October of this year, we must complete the work on the withdrawal, and between October and March, we will finalise what we're implementing, so that when the signing of it occurs, we will know the complete deal. That was the policy. When did that change, Secretary of State?
Well, I think on your first point, which is
no, when did it change? I don't want the waffle. When did it change?
Well, I think there were several points you raised, so I was just going to go through the different ones. So firstly, you raised the issue in terms of whether the implementation period is time limited. I think the answer to that is yes, it is. It is up to the end of 2020.
No, it's not. No, come on. No, Jim, you can't get away with that. You know that there is an option to extend that.
Well, it's just coming on, though.
So it's not time limited, is it?
Mr. Ben, never mind trying to get away with it. I was just about to make the point. So the point I was seeking to make, if I may, is it is time limited to the end of 2020, but with an extension of either 1 year or 2 years. But even so, by its nature, that is time limited. I would hope that is a point of consensus.
No, the trouble, the Prime Minister said it was time limited to 2 years.
Well, it's 2 years with the option of a 1 year or a 2 year extension.
Change? When was the policy changed? That's all I'm asking.
Well, I've been in post for 16 days,
sorry,
so I don't
perhaps
particularly...
it should be directed to Mr Robbins, who was there. Mr Robbins, when was the policy changed?
So the policy on the implementation period for some time has been that we would aim to have concluded all of the negotiations of the future relationship in order to allow it to take effect in December 2020, and that's what the treaty sets out. And in the closing weeks of the negotiations, ministers felt it was prudent to allow for the possibility of extension. It's no more than a possibility, and it has to be by mutual consent.
But I think
sorry, I'm still trying to find out when the Prime Minister's clearly expressed policy to Parliament, which kept members of Parliament reasonably happy on compromising that they could go along with, when was that policy abandoned? Now, I expect to say you've only been there 2 weeks, so you wouldn't have been there. But Mr Robbins, you've been there right at the top. I'm not asking for any explanation. I just want to know, when was it abandoned? You know, a month ago, 4 months ago, 6 months ago?
So I don't think that policy has been abandoned with respect, Mr Bone. The policy is to conclude the negotiations of the future relationship in time to leave the implementation period on time by the end of 2020, and the treaty sets out that we will use our best endeavours, both parties, to achieve that aim.
Yeah, no, but you have to accept, Mr Robbins, that is a complete change in the policy of the Prime Minister, clearly expressed that at the time when we signed to leave, we would know what we were implementing, whether that was a free trade deal or what. Now, that has been changed. That policy clearly has been changed.
No, I don't accept that, Mr Bain. I think the 2 points at the heart of your question is, first, is there a time-limited implementation period? The answer is yes, to the end of 2020. Now, we have given ourselves an option, but the fundamental point is it is time-limited to the end of 2020. That's the first point. Secondly, will we know what we're implementing? We have a clear framework. Mr Robbins has already talked in terms of the amount of resistance there had been, the extent of the detailed negotiation to secure that, and that is the clear negotiating instruction. And what it delivers is a bespoke arrangement, which is something that the Prime Minister was consistently told she wouldn't be able to secure.
But that's all well and good. But the Prime Minister clearly said we are not going to spend £39 billion of taxpayers' money without knowing exactly what we were going to implement. Now, that is a change in policy. I'm not saying whether it's a right or wrong change in policy. I'm just asking, when was that decided and how was it decided?
Well, I don't accept the premise that it was a change. I think the issue in terms of the 39 billion, which I know you've raised a number of times in the Chamber, and very happy to get into the detail around the methodology of that, what that relates to, why that range of 35 to 39 billion has been agreed. But that has been agreed on the basis of us maintaining our relationship with our closest trading partner. That is what the political declaration allows us to do, and what it does is give clarity as to the fact that we are not going to be in a standardised arrangement as other third countries, and reflecting the very close, over 40 years of relationship, the shared values that we have with the EU 27, and reflecting that, the Prime Minister has secured a bespoke deal, and that is what we're paying for. Now, the 39 billion we can very happily get into, but there are a number of...
Mr Chairman, because we've heard all this, it really doesn't help the debate when politicians and civil servants just don't answer a straightforward question, is when did the policy change? And if you had something to implement, then you would be fair, but you have nothing to implement. So the policy has been changed, and when? And if you don't accept that, it makes the whole of these sort of debates farcical.
No,
you're flying in the face of the facts.
With respect, I don't accept that, because the policy hasn't changed. The 39 billion, I mean, there's a whole different debate we can get into the financial settlement, into what David Cameron agreed in 2013 as part of the multi-year, same-year settlement, the fact that under the implementation period it takes us to the end of 2020, and how those liabilities sit with the trade-off in terms of what assets we're getting back from, for example, our shareholdings from the EIB and others. I mean, that is a very different debate. Obviously, we can explore the issue of the 39 billion and the negotiation Mr Robbins and the team had, but that is a separate issue. The issue is that the Prime Minister has always been clear that there would be a time-limited implementation period. That is the case. It's till 2020. Personally, I think it's a good thing to have an option. Why would we not want to have an option? I don't think that's a negative. We don't have to use it. So it strikes me as a logical thing to have. But it is time limited to the end of 2020.
Thank you, Chairman.
And beyond that, it's part of the arrangement.
Okay. Pat McFadden.
I'm sorry, I'm a little bit croaky. Secretary of State, could I ask you if you think there are any circumstances between now and next Tuesday where the Prime Minister will pull the vote?
No, I think the vote will happen on Tuesday, and I'm very much looking forward to making the case. I think the Cabinet has an important job. It's for the Cabinet as a whole to make the case ahead of Tuesday. And I think certainly what I hear from businesses up and down the country is many businesses themselves are making the case because they don't want the uncertainty that will flow if this vote does not go through.
So there's no chance that sometime between now and next Tuesday, the Prime Minister will look at the likely numbers in the Commons and decide not to proceed with the vote on Tuesday. That won't happen.
I think the meaningful vote has been set out for the 11th, and that is what I expect to be the case.
Expect?
Of course.
Anything stronger than expect?
Well, I mean, what more would you like me to say? I've answered the question twice. I expect the vote on Tuesday, Mr. McFadden.
Okay. Can I go back to this question of money? Your predecessor made quite a lot of the conditionality of the financial settlement, that it wasn't just the settling of past accounts, that this would only be paid if we got a satisfactory result on the future relationship. Has that been built into the withdrawal agreement, and if so, where?
I missed the last
Has
bit.
that conditionality been built into the withdrawal agreement, and if so, can you tell us where?
Well, I think, and they, the House of Lords reports that looked at this issue as well, and the importance of the financial settlement in terms of our sort of wider relationship. So I think there's a what's in the withdrawal agreement is the mechanism as to how the financial settlement has been calculated. What will then be in the bill will be the process by which we will pay. And again, I think that's one of the distinctions sometimes people confuse between the two. So the withdrawal agreement will set out the principles on which the financial settlement will be calculated. That's why there's a range between the 35 and 39 billion rather than a precise figure. But beneath that methodology, there's a complex interplay between what liabilities the UK has and in terms of what assets we would get in return and how those will interrelate.
No, I understand all that. The question I'm specifically asking is whether, whatever the actual sum is between the 35 and the 39 and so on, whether there is conditionality on paying that linked to a successful outcome on the future relationship, or whether that is legally binding on us once we ratify the withdrawal agreement. And if there is conditionality built in between stages 1 and 2, as it were, can you tell us the clause in the withdrawal agreement where that applies?
May I support you here, Secretary of State? Just to add, as I've tried to bring out a bit from Ms Reynolds earlier, what the withdrawal treaty does in Article 184 is provide for is to create an international law obligation on both parties to turn the political declaration into legally binding agreements. That's therefore an obligation on both sides, and it's an obligation that needs to be read with Article 5, the withdrawal agreement, that compels both parties to use good faith in delivering on all of their obligations in the treaty. So the reason this is relevant is because clearly there are financial obligations in the treaty. There are also obligations to negotiate in good faith that future relationship. And so in that sense, the two are linked.
Sorry, I'll just give the bell a second. So do you see that Article 184, Ollie, as giving the UK the ability to say we're not going to pay part of this financial settlement at some point in the future?
So I think I think the correct legal view, but this is something that the attorney will no doubt be probed on this afternoon, the correct legal view is it creates an international law obligation on both parties to negotiate. That is not the same as an obligation to reach a particular outcome, but it's an obligation to negotiate in good faith. These clauses are not completely unheard of in international law, and the best endeavours provision here is, we believe, a strong one. What it means is that if there is obvious signs of bad faith in the execution of that obligation, then it raises a question that in the end will be susceptible to arbitration as to whether the other party is in breach of its obligations and which other obligations of the agreement should be suspended. I'm sorry, I know that's a slightly sort of techie answer to the question, but I want to be as accurate as I can be.
So there are circumstances under that article where the UK might say we are going to suspend payments or not make payments under the financial settlement if the UK judged that the future relationship negotiations were not being conducted under best endeavours or something like that?
I think what Article 5 of the withdrawal agreement does is create a very strong explicit presumption that both parties will execute all of their obligations in the withdrawal agreement in good faith. And if that's called into question by one party or the other, there is a strong dispute resolution mechanism in the treaty that deals with that eventuality, up to and including the ability for an arbitration panel to endorse the suspension of aspects of the agreement.
Okay, can I ask you one other thing, Ollie? I should echo what the Chairman said about your efforts and the efforts of your team in putting all this together. It's been a huge effort and body of work. I want to ask you really about the link between what we're already committed to in the December agreement last year and the withdrawal agreement and the shape of the future. Because there's been talk about a spectrum of outcomes, and it's not just Canada or Norway. You know, we've now got a more open canvas, as it were. But is that really the case? In other words, what I'm saying is, aren't the commitments that the UK has made to keeping an open border for the future, which is why we've ended up with a backstop, don't they also inform the shape of the future relationship? In other words, these questions of customs alignment, regulatory alignment so that the free flow of goods can continue, don't they inform the shape of what comes out in that spectrum that you referred to?
So, may I actually say, first off, I mean, I think the backstop has been a very, very particular instance of a much longer, deeper, difficult policy discussion with the European Union about how you avoid friction at a border. And I wouldn't want to pretend to you that we have yet won that argument in terms of what the government put forward in July as being the right systematic answer to that question for the UK as a whole. But what I think the Secretary of State and I are trying to explain is that by joint agreement with the EU, what we have ended up writing together in this declaration does not preclude that being the right answer. And certainly, as the Secretary of State brought out more strongly than me, it's brought out the joint determination of both sides to find a better way of doing it than is laid out in the backstop.
See, I think in a way you've been done a disservice because I think the commitment to no hard border, which is right and understandable that the country has made that commitment, and the commitment to frictionless trade point to an outcome. Both of those commitments point to an outcome where we're adhering to one set of rules. And I think it would be better for ministers to have been candid with the public about that, instead of pretending that we still had a full canvas of options when those commitments clearly point to one kind of outcome in terms of our future relationship with the European Union.
I don't think there's a lack of candour. The point is, as Ollie's just alluded to, is there's a spectrum of options, and what the negotiation has done is keep that open. And I think that's part of the achievement that the Prime Minister has made. Clearly, frictionless trade requires more alignment. And there's a question then as to how that in the phase 2 is negotiated. But the point is the option of frictionless trade is still on the table, and that's clear in the political declaration.
But let me put it, I'll ask this one last question, Mr. Chairman. Let me put it a slightly different way around then. Do you believe that a Canada-style deal is consistent with the UK's commitment to no hard border and to have frictionless trade?
Well, the phase 2 negotiation will need to get into the detail. We start from a position, let's not forget, it's a referendum of alignment because we've been part of the EU. So we start from a very different position to the Canadians and to others because we are already aligned. What's also clear in the text is the shared commitment on both sides in terms of the shared values. Now, so that's the premise through which the negotiation will be conducted. But this will be part of the detail of what we explore in phase 2.
No, I'm going to press you a little bit further. I'm sorry. Would a Canada-style free trade agreement or the Japan free trade agreement, one of these, latest in class EU free trade agreements, be compatible with the commitments that your government's already made? It's not a trick question.
No, I'm not suggesting for a minute, but what I'm saying is that it's in both sides' interest. I mean, let me give a specific. So if you take medicine, I mean, there's been a lot of debate in terms of the importance of keeping the supply as frictionless on medicine. What tends to get less coverage is there's 45 million packages of medicine that go from the UK to the EU each week. So it's in both sides' interest to have frictionless trade. That is in the mutual interest of ourselves and the EU 27. Then within the phase 2 discussions, we will need to then get into discussion from a starting point of regulatory alignment, which is what is part of the unique relationship we have. We start from alignment as to how that will be managed alongside with the aspiration, which is as frictionless as possible.
At some point, you're going to have to level with the public about what these commitments on no hard border and frictionless trade mean. And part of your trouble is that that hasn't happened so far. So people are being told that all these options are on the table when they're not really. And I think that moment should come sooner rather than later. I'll leave it there for now.
I recollected that the Prime Minister had actually said that she thought a no-deal Brexit would be better for the UK than a Canada-style agreement. I think that's what she said when she was at the United Nations. But anyway, we will move on. Chris Chope.
Thank you, Can I take you back, Secretary of State, to this issue of the relationship between the withdrawal agreement and the future arrangements agreement? We are fortunate in having received advice from the House of Commons EU legislation team on this issue. And the legal note that they produced says the fulfilment by the UK of its obligations under the withdrawal agreement, for example, making payments under the financial settlement, are not conditional on reaching a satisfactory future arrangements agreement. The legal advice then goes on to say that refers to Article 184 and to Article 5, and says, whilst these are legal obligations at the international law level, they do not stretch as far as obliging the European Union to enter into a future arrangements agreement which it does not consider to be in its interest. And if the UK wanted to try to enforce this obligation, the obligation to use best endeavours and be of good faith, the legal route of recourse would be by complaint to the Joint Committee and ultimately dispute resolution before the European Court of Justice. Then it goes on to say that there is no compulsory system of determining and enforcing any sum that might be owing under international law, and that the degree of detail in the political declaration affects the assessment of the risk of the lack of conditionality in the withdrawal agreement. The language of the political declaration varies. Some provisions are couched in firm language, with or without conditioning words. Some are matters for consideration or exploring, or matters the parties envisage happening. Do you accept, Secretary of State, that that is an accurate assessment of the legal status of the linkage between the withdrawal agreement and the future agreement, the future arrangements agreement?
2 points. Firstly, the financial settlement, and perhaps if I just reference the Lord's report, because the Lord's report is often quoted as grounds for not making any payment at all, that we shouldn't be making any payment under the 39 billion. And Para 137 of the Lord's report said, quotes, the political and economic consequences of the UK leaving the EU without responding to claims under the EU budget are likely to be profound. And as the Prime Minister has repeatedly set out, we are a country that honours our obligations. Those obligations are significantly less than the EU was looking for. They started at around 100 billion, I think, from memory, and we now have a range of 35 to 39 billion. So, and as part of the implementation period, we are obviously continuing to gain many of the benefits, including the receipts that come our way from assets and other things. So the point is the financial settlement reflects our legal responsibilities, our legal obligations. The Lord's report recognises that, and I think that is absolutely right. There's a separate point in terms of whether the EU, as part of the political declaration, honours the commitments it's made in that political declaration. I think we've already covered that terrain to some degree, in that there is a clear legal connectivity between the withdrawal agreement and the political declaration. There's also a political, I think, responsibility, political commitment which is partly why that document was subject to such negotiation. And so I think it does set the clear direction of travel for the future trade agreement, but it is connected to but not dependent on the financial settlement.
So you accept what the legal note which I've read out asserts? You accept that?
Well,
there's nothing wrong with it. There's nothing wrong with accepting
What I accept, Mr. Chope, is that as part of our legal obligations, we have legal obligations to the European Union, and as part of that, that does require a contribution. And I know there are some colleagues, including around the table, who feel that we shouldn't pay a penny to the European Union. And I respectfully disagree with that position, because I think, as the Lords have set out, walking away from our legal obligations and not paying a penny, I don't think would put the UK in good standing as we go out into the world to trade.
And that's not the question I'm asking about. I'm asking about the conditionality and the linkage. And can I remind you, Secretary of State, that when the Prime Minister made her Lancaster House speech, she said, I want us to have reached an agreement about our future partnership by the time the 2-year Article 50 process has concluded. And you would accept we haven't got anywhere near reaching such an agreement about our future partnership. And the reason that the Prime Minister wanted us to have agreed both things was so that there could be linkage between them, and we wouldn't end up paying £39 billion without being sure what we were going to get in return.
The point is, it depends. It really, the crux of the question goes to the specificity of how much detail is in the agreement. The point is that the political declaration does have clarity in terms of things that the European Union have agreed. The UK, as part of our future relationship, will be able to enter into with them. It's perhaps not to the level of detail that you would prefer, but I would argue that it is significant. But Ollie, I think you wanted to just come in on that.
I just wondered if I could help on the specific question you were asking about the publication you referred to. Just to say to the committee, I think whilst we've been here, the government's published its own legal assessment of the withdrawal treaty, and there is a paragraph at 77 of that document that explains our take on Article 184 and Article 5. I think to a non-lawyer, what it says is not inconsistent with what you read out, Mr. Chope, but it's the important point that I was trying to get across to your colleagues is that what 184 does is it creates an obligation as to the conduct of the parties. It doesn't create an obligation as to a particular outcome, but it says that the conduct of the parties must be informed by this political declaration.
And anyone that's more familiar with the commercial courts will know that you can't legally compel another party to conclude a legal agreement. What you can put into legal text is a requirement for another party to act in best faith, to act reasonably, those sort of requirements. You can't compel them to conclude. And in essence, that is the distinction that's coming out.
Well, I don't think anybody's disputing that. But you've said, Secretary of State, that it's all quite clear. Can I ask you, give you some specific examples that in paragraph 26 of the political declaration, it says the parties will put in place ambitious customs arrangements. What does that mean? Then paragraph 54 says the parties agree to consider addressing social security coordination, to consider addressing social security consideration. And then in paragraph 55, the parties will explore the possibility to facilitate the crossing of their respective borders for legitimate travel. And then in paragraph 20, the parties envisage having a trading relationship on goods that is as close as possible. What legal enforceability is there in relation to any of those vague, waffly, ambiguous phrases?
Well, the text refers to it being a framework. What this is doing is setting in essence, the negotiating instructions, the framework for those future trade agreements. I'm not suggesting to the committee there isn't significant work to do in phase 2. as we put those into legal text. But what it does show is the framework in which the EU27, the Commission, the UK will conclude those trade agreements. That's what's being set out in the political declaration. And as Ollie has referred to, there are clear legal underpinnings to that in terms of the way the European Union must undertake and conclude those negotiations. That's what has been agreed.
Okay, finally, can I just say this? You and I, Secretary of State, were both elected on the same manifesto in 2017. Page 38 of that manifesto said, "We believe it is necessary to agree the terms of our future partnership alongside our withdrawal, reaching agreement on both within the 2 years allowed by Article 50 of the Treaty on the European Union." You've admitted today that that commitment in our manifesto has been abandoned.
No.
Can I go back to Mr.
haven't.
Bowen's question and ask, when was it abandoned?
No, well, with respect, I haven't said anything of the sort. What that set out was that we would reach an agreement after a very intense 2-year negotiation. The Prime Minister has secured that agreement. One of the concerns that colleagues across the House has raised as to the legal force of that agreement, and we've covered today in the session the legal connectivity as to why the legal text in the withdrawal agreement gives effect to the political declaration. But it's simply not the case to say that an agreement hasn't been reached. The political declaration has been agreed with the other side. That sets a clear template, a clear framework. It perhaps doesn't have the level of detail on every issue to which, Mr. Chope, you were hoping, but I don't think it can be said that an agreement has not been reached. It has.
Okay.
Thank you, Chair, and thank you for coming to answer our questions. Now, we heard this morning that an immigration white paper will not be coming before the vote. Perhaps you can help me out. In light of the government's intention to end free movement after December 2020 and introduce, as you have already said this morning, a skills-based immigration system, I asked the Prime Minister last week a question. And I asked, in January 2021, an incoming EU citizen coming to Dublin, travelling on to Belfast and then to the rest of the UK, where will the immigration border be? And the Prime Minister answered that there would be no immigration border because we are in the common travel area. Does this mean the government actually had discussions with the Republic of Ireland that they too will introduce a skills-based immigration system, or that they also will end free movement of EU citizens, which I don't think, because it would be very amazing news if that had happened. So I assume not. And therefore I repeat my question. In January 2021, an incoming EU citizen coming to Dublin, travelling on to Belfast, and then to the rest of the UK, where will the immigration border be?
Would it help if I came in here, Secretary of State? I think the Home Office's plans, which, as the Secretary of State has said, will be set out in detail in due course, are based upon the idea that for most EU citizens, the immigration control, your right to work and stay in the United Kingdom, will not be exercised at the border, but exercised in country. So what we're talking about here is that I don't think either side wishes to gum up the border by removing the e-gates and doing all sorts of things that will make it more difficult for people to move for legitimate purposes in both directions. But what that means is that people coming through Ireland into the UK, either via the Northern Ireland or directly, if they want to work and to stay in the UK, they'll have to comply with UK immigration law if they're EU citizens. But it doesn't mean that you need hard infrastructure between Ireland and the UK any more than you need more than the e-gates today.
Can I ask again? But somebody coming into Dublin, it would then be the Irish government that would check that an incoming EU citizen would have the right documents either to work or to travel in the rest of the UK. Is that what you're saying?
No, I think the Home Office will set this out in more detail, but the kind of in order for this to work, for someone to work in the UK, they will need the correct documentation to be able to work in the UK, and that's very similar to somebody arriving today. What it doesn't imply is any new particular control on EU citizens coming in through Ireland.
Or indeed from France to the UK, because there's a reference to, for short-term visits, that visas would not be envisaged, and therefore someone from any EU country could arrive in the UK at Heathrow Airport, and if they're coming on holidays as tourists, they could do so. They wouldn't require a visa or a permit. That's my understanding of what the government's plan is. But as you've just said, if they want to rent property or work, then they would have to get the appropriate permission, visa of some sort, depending on what the Home Office eventually announces. Is that what the government's intending?
Well, the immigration white paper will set out the detail on this. I think what Ollie was referring to is currently employers have responsibilities on registering, and so it will be for the white paper to set out to what extent that has a read across. So
but you're not proposing visas for tourists coming to the UK. Well, I think
there's already
from
the EU as well commitments around 160-day visits, I think, for businesses and tourists, and I think that agreement's already been reached with the EU, and that's in the text. So again, I think that one's already been covered, hasn't it?
Yeah. So I mean, I think this is an area, Ms. Hophouse, where the phrase free movement is a bit misleading. Free movement, the full phrase was always free movement of labour, and so for people to be able to live and work in the UK, there have always been requirements in order to ensure that that's done legitimately. And obviously, depending on the Home Office white paper, we'll be looking again at what those requirements are in future. In terms of moving across the border, the Chairman is right that the government has said for some time it doesn't want to make that process any unnecessarily more difficult for people than it is today.
But can I insist, the UK, as I understand it, will want to move away from an immigration policy that's different from the Republic of Ireland, because in the Republic of Ireland, EU citizens can continue to come and get, have free movement of labour, whereas that will terminate for EU citizens wanting to work in the UK. So there will be a divergence of policy, and how can who is going to be responsible to actually check a work visa of an EU citizen that is different from what the Republic of Ireland requires?
Well, I think firstly let's just distinguish, because under the implementation period, EU citizens would be free to travel.
No, I asked 2021.
So that is what the Home Office white paper will cover. But the point is, in the short term, the implementation period, the status quo would continue.
My question was for 2021, and we do not know at all what this arrangement is going to be like, because the white paper is not being published.
Well, I think the wider direction of travel that government has signalled is that we want to move away from a nationality approach to much more of a skills-based approach. So one would expect a direction of travel more akin to other third countries, but it will be an issue for the immigration white paper to actually set out the detail.
So we don't know yet?
Well, the immigration white paper will set out the detail. I don't think it's appropriate for me to preempt. And again, I mean, there's a fairly standard approach to these things that other departments set out, and Mr. Krauss, being a member of the Cabinet, he is familiar with it. Other departments will set out their approach in due course. I don't want to preempt another department's announcement.
Can I ask one separate question?
Yep.
So, your predecessor only on the 21st of October said a good deal is in sight. And on the 23rd of November he said this deal would be worse than membership. What has changed within that month? Because obviously for bystanders and outsiders this is extremely difficult to understand. What has changed in that month, or did your predecessor suddenly have a light bulb moment?
No, my predecessor is one of, I think, the most respected. He's very bright, and I think very respected by people across the House, and he's can very eloquently speak for himself. So it's not for me to comment on the position that he's taken. I think the point is that, from my perspective, it is a question of assessing the balance of risk. The risk of uncertainty, in my view, is one that would be very concerning to business, concerning for jobs for my constituents and yours. And we have a deal on the table which respects the result, delivers on the referendum, delivers on things which you've just been referring to, like a skills-based immigration system, such as on having control of our fishing waters, such as taking our agriculture out of the CAP. I represent a farming constituency, where the CAP has long been a cause of concern. So it delivers on the referendum result, but does so in a way that delivers those frictionless an approach at our borders, which is good for business. Dominic, as I say, will speak for himself, and I think I should...
But nothing changed in that month in terms of the direction of the outcome.
I think, as I say, Chair, I think it's for Dominic, as a former member of this committee, no less, will speak for himself in due course.
You're the first Secretary of State for exiting the European Union who has not previously been a member of this committee. So that's a claim to fame, if nothing else. And, well, indeed. Right, Andrea Jenkins is next.
First of all, Secretary of State, wish you good luck in your new role. I know it's a challenging time ahead. Secretary of State, next week we are voting on your deal, and in your opinion, are you confident that you're going to secure enough votes to get it through the House?
Well, I think it's going to be challenging. I think everyone recognises that. It's an issue on which a great deal has already been said. But there is clearly time between now and the vote. And I think
so will it get
what has
through?
come... Well, as a former whip, one waits for the vote to see. But I'm confident that we can deliver this deal because I think it is in the national interest. We've had a very divisive...
You're confident you can deliver the deal, but
well, I think, as I
say,
I think it's challenging. It's challenging. It's challenging because a lot of colleagues have already spoken out on this, and I think part of the challenge is this complex legal wiring between the withdrawal agreement and the political declaration. It's complex in terms of the economic analysis. It's complex in terms, well, one can run through a
So assuming
wide
it doesn't
list
get
of
through
issues,
next week, Secretary of State, what's your contingency or plan B?
Well, our focus is on delivering the vote, and that's what we're focused on. And
but surely it's the job of government to look beyond that, because we know...
One hears a lot about this plan B. I mean, the Prime Minister has been very clear that...
So there is no plan B? There's no contingency plan?
The focus of government, Ms Jenkins, is on delivering this vote. That is
but
what
what
I am focused
fails?
on. Well,
What happens
in
the day
that
after the
event,
vote?
obviously government would have to look at the consequences in due course. But the focus of government is on...
the next day, you know, say the vote gets voted down, what's going to happen? I think the public want to know, the committee wants to know, the country wants to know.
Well, people often challenge politicians for honest answers. The honest answer is it's unclear, because it's unclear how
so you don't
Parliament...
have a plan?
Well, it's unclear how
Mr.
Parliament...
Robbins, could you answer this?
No, if I can finish the question. So the point is that we could be in a situation with no deal. We could be in a situation with no Brexit. I think there's significant problems with both of those courses. But what I can be clear on is the consequence of the vote not going through next week would be uncertainty for business, uncertainty of jobs. There's businesses that want
even
to
more
invest.
Uncertainty if the government and the department hasn't planned.
Well, we have. I mean, it's a separate issue to come on to the work that we have been doing for no deal preparation. It's work that Steve Baker did when he was the no deal minister. It's work that Chris Houston-Harris and colleagues across government have done a huge amount of work. But the clear
so are you
view...
saying, Minister, then that really you don't know, you're deciding after the vote?
No. What I'm saying is that it will be... I mean, Parliament will obviously have views on this as well. But it's the focus of government is delivering the deal. This is the best deal for the country. It is
the best deal for the EU, I hasten to add.
Well, your views are on record, and obviously I have read those. But the point is that this is the only deal. The EU have made that clear. And it is a deal that allows us to deliver the certainty that business needs, but also that for those of us, as I know you did, that campaigned for Brexit, that wanted to see a skills-based immigration, that wanted to see us take control of our fishing, that wanted to ensure that we were out of the CAP, that wanted to ensure that we had an independent...
With respect,
that's what this deal is about.
Mr. Robbins now.
That's what this deal is about.
Thank you very much for answering that, or not answering it in the case. So, Mr. Robbins, you've been on this right from the beginning, for a very long time. So, what do you think is going to happen, or what have you advised the Prime Minister to do if it falls next week, the vote?
I can't really add anything to what the Secretary of State has said, Ms Jenkins. The focus of the whole government from the Prime Minister down is on delivering the deal.
But do you think that's actually good planning of the government if they haven't got a plan beyond the vote?
I think the government is doing.
We have plans, as I've touched, generally, we have plans in terms of a no-deal scenario, but I think that would be damaging to jobs, it would be damaging to business. But are there plans for a no-deal scenario in the event that the government does not secure the vote? Yes, there are. And a huge amount of work has gone in behind the scenes in government on those plans. But the focus of government is on securing the vote because that is in the national interest.
Right, thank you. Secretary of State, in his resignation letter, David Davis said that the Prime Minister's Brexit policy would put the country in, at best, a weak negotiating position and possibly an inescapable one. Furthermore, it said the policy will make control by Parliament illusionary rather than real. And finally, the Common Rulebook policy hands control of large swathes of our economy to the EU and is certainly not returning control of our laws in any real sense. Was David Davis, the Secretary of State for 2 years, wrong? And if not, what dramatic changes have been made to the deal to put Mr Davis's concerns at ease?
Well, the biggest part of our economy is services. And this deal doesn't put services in anyone's control, quite the opposite. So I'm just taking that as just one example. So no, I don't accept. I mean, I obviously hugely respect the work that David Davis did in the department and also in government, and also incidentally as a parliamentarian. I think he's a parliamentarian of huge standing. But to say that, a precise quote, that this puts our economy in the control of others, well, you know,
that was a resignation letter.
Well, indeed, but as our services in particular, as the former Minister for Financial Services, I know that services are a huge part of our economy. They're also, as someone who wants to take a much more global approach in terms of moving forward as part of our future approach. If I look at areas such as asset management, where the UK has huge opportunities, I look at areas like fintech, insurance. There's massive potential for the UK within financial services. The idea that that is in someone else's control, I'm afraid, is just not correct.
Thank you, Minister. You've stated that about a global approach. I'm sure everybody in this room would like to agree with that, whether you're Brexiteer or Remainer. So, Secretary of State, is it more or less likely that we could achieve a free trade deal with the USA under WTO rules or under the PM's deal? Is it more or less likely?
More likely with the USA under...
So is it more or less likely that we could achieve a free trade deal with the USA under WTO or under the PM's deal?
Well, I think what the PM's deal secures is...
but is it more or less likely? It's a simple question.
More or less, sorry.
Are we more likely to achieve a free trade deal under WTO rules or under the Prime Minister's deal?
Well, I think the PM's deal allows us to secure a deal with the US. I think the point is that...
You're saying more the PM's deal, we're more likely to...
No, I think the PM's deal is in the better interest of the economy, and I'll explain why. Because Europe is our largest trading relationship. It's important we maintain that. But in terms of the political declaration, it made clear on page 1 that it will both respect the referendum result and enable us to have an independent trade policy that enables us
so is President Trump wrong, Secretary of State, when he says it would be very difficult to get a deal with the US under the Prime Minister?
Well, I note the comments of the President. Obviously, that's hugely significant because he is President of the United States, but I think that's also been put in context by the comments of the US Ambassador recently. It's also been put in context by the lead negotiator for the trade envoy, who's written to Congress in the US, signalling their desire for a trade deal. Liam Fox has done a huge amount of work. But one should also bear in mind the balance in terms of the amount of trade we do with Europe vis-à-vis the US.
Okay, thank you. A couple more questions, if that's okay. It's very quick ones, actually, Chair. Thank you. Mr Robbins, just briefly touching on what my colleague Jacob mentioned about the Daily Telegraph. If you have actually warned the Prime Minister, then I think as Brexiteers want to commend you for warning her on the issue of the backstop. But can I just ask, Are there any other occasions when the Prime Minister has failed to listen to quite fundamental advice?
Ms Jenkins, I'd like to think that the Prime Minister listens to the advice she gets from across the system, including from her ministerial colleagues, all the time. And I have to say, I think my experience over the last 2.5 years of working for her and ministerial colleagues on this subject is that they have approached the issues and the options with incredible seriousness. And so the kind of views that Mr Rees-Mogg were putting to me earlier have been part of a very healthy process of myself and colleagues across government in making sure that ministers take the full suite of options and issues very seriously.
And final question, please, Chair. Thank you, Mr Robbins. Mr Robbins, are you aware of any advice shown to ministers on the legality or feasibility of a second referendum?
I'm not aware of any, no.
Okay. Thank you.
Right, Peter Grant.
Thank you, Chair. The Prime Minister within the last couple of weeks has suddenly started to talk up the possibility that Brexit might not happen, presumably to scare off the ERG and their fellow travellers. The Environment Secretary has been saying something similar over the weekend. But as recently as 5 days ago, the Secretary of State for Scotland was telling the Commons that voting against the deal means voting for no deal without any other option being on the table. They can't both be right. So which of them is right and which of them is wrong?
Well, it's a matter of government policy that there will not be a second referendum, and it's the firm government policy that we won't revoke Article 50. So I think the government's made its position on a second referendum very clear.
Yeah, the government has changed its policy on what Brexit means and doesn't mean more times than most of us can count, as a few members have already pointed out. The Prime Minister has chosen on a number of occasions to remind us that it's possible that Brexit will not happen. The Secretary of State for Scotland is saying that it's either this deal or no deal. Do you agree with the Secretary of State for Scotland when he directly contradicts what the Prime Minister has said?
Well, I think the point I've just made is that, well, firstly, the government is committed to the deal. It is the only deal. The European Union have made that clear. We are planning as a default option if the deal doesn't go through, because then obviously one needs to prepare in case there is no deal. But in terms of a second referendum, it is not government policy. And I think there's significant difficulties that would arise if you tried to have a second referendum. If you just look at the amount of time, I know there's colleagues around the table that are keen on a second referendum, but if you just look at the logistics of that in terms of how long it takes to pass the legislation, the need for a regulated period before a referendum, and the need for time post that referendum, depending on what the result would be, and the fact that it is not a unilateral decision as to whether you extend Article 50. That is a decision taken by the EU 27.
The Environment Secretary went on national media at the weekend to say that a second referendum is a possibility. Was that line approved by the Cabinet or by the Prime Minister, or was the Environment Secretary just going off and making up policy on the hoof?
Well, I didn't say that particular interview, but I can't be any more clear that firstly it is not government policy to have a second referendum. That's the clear position. I think that would be hugely damaging democratically. We had the biggest vote in our country's history, and we have a deal on the table that respects that. The EU have made clear it's the only deal. But also, I think there's significant difficulties in trying to have a second referendum. As I say, it wouldn't be within our unilateral control, but also it'd open up other questions. Would you then, as a member, have would we have the European parliamentary elections if we were still a member if we extended? I think there'd be huge complications around that. But the fundamental point is there'd be uncertainty for businesses. It would be massively divisive to the country. And I think after 2 years, which have been very troubled and very divisive, it is important we bring the country back together. We have a deal on the table that both respects result but also keeps our close ties with Europe. And it's time now that we get behind that in the national interest and bring the country back together.
Thank you. Can we look now at the long-term economic analysis that the government published last week? Can you confirm that every scenario that was looked at in that analysis indicated lower economic growth than we would have had if we'd stayed in the European Union?
Well, I think firstly with the economic analysis, and I think sometimes people see that as a forecast to a landing zone when actually it's a direction of travel. But also what that was looking at was the rate of growth. I mean, the fundamentals, as the Chancellor has set out, the fundamentals of the economy are very strong. And the question within the economic analysis was twofold. Firstly, within the rates of growth, what impact would different scenarios have? And what was very clear from the economic analysis was that the Prime Minister's deal is the best deal economically. So that's the first point. And secondly, alongside that, government there would be a number of other factors that would have a bearing on what the actual end result, and this was a 15-year projection, is worth reminding, but there'd be other factors. So what you do, demographics, migration, technology, there's a whole range of factors that would shape that economic analysis. But the key point of it was that it showed that the PM's deal was the best deal for the country.
With respect, Secretary of State, what I asked you was to confirm, as a matter of fact, that each scenario that was looked at in that analysis indicated a lower long-term rate of economic growth than the baseline of being in the European Union. Can you also confirm that in each scenario where the impact, assuming there was no change to inward migration, compared to the impact assuming a significant reduction in migration from the European Union, again, in every instance where the government have chosen to publish that analysis, it shows that a cut in immigration from the European Union leads to lower economic growth than current or what would happen under the status quo. That, as a matter of fact, isn't it? That's what the analysis indicates.
Well, I'd say two things. I think, firstly, I mean, in answer to your question, yeah, there's, I think, from memory, 0.7% difference, but that's taking things in isolation without, as I alluded to, the other things that would happen alongside that. So it's taking it in a very sort of binary sense without looking at the wider picture. Secondly, in terms of migration, yes, from an economic point of view, if you look at it in pure economic terms, the Treasury scores migration in a positive way. But that's just one aspect that we have a commitment through the referendum in terms of concerns that were raised in the country around freedom of movement. That is why we are moving to a skills-based. So one can't look at these things in isolation in a very siloed way. You need to look at them in the round.
Going back to the result of the referendum, I noticed that government ministers are very good at knowing exactly what was in the minds of all 17.5 million people when they voted to leave. Certainly the ballot paper I had only said remain or leave. It didn't ask about anything else. How many of the 17.6 million people do you think deliberately voted for lower economic growth and therefore presumably for a lower standard of wealth and income for themselves and their families than they would have had by staying in the
But I don't accept the premise of that question because, as I've alluded to, firstly, the deal that's on the table from the Prime Minister is the best deal. That's what the economic analysis shows.
It's the best one within the red lines that the Prime Minister set out.
Within the assumptions set out for that economic analysis, but what that economic analysis shows is, firstly, it's a direction of travel. It's not a forecast to a precise landing zone. And secondly, there's a whole range of other factors that will shape where we eventually land in terms of the actual final outcome. So one can't take it in isolation. One needs to look at that wider picture.
Thank you. Can we look now at paragraph 75 of the proposed political declaration, which is one of the paragraphs that looks specifically at fishing. That paragraph commits the government and the EU to establishing a new fisheries agreement that includes, and I quote, agreement on access to waters and quota shares. Now, one of your cabinet colleagues about 2 weeks ago signed a letter that stated, and I quote again, access and quota shares cannot be included in the future economic partnership. Do you agree that the political declaration as it stands just now is incompatible with the demand that was made by your colleague when he said that access and quota shares had to be excluded from the future partnership?
So what the political declaration does is ensure that there isn't a link between a future agreement on fisheries, including access to waters, and any agreement on trade. But what I'd quote it would be Bertie Armstrong, who, as you know, is the Chief Executive of the Scottish Fishermen's Federation. And what he says is that, and I quote, "The declaration gives the UK the power to assert its position with full unfettered sovereignty over our waters and natural resources." So this is a deal that is welcomed by the Scottish Fishermen's Federation, and that is, I think, an indication of the fact that it ensures we take back control as an independent coastal state of our fishing, and then we're in a position to negotiate it, just as other countries like Iceland do, moving forward.
The statement the Prime Minister made on the 22nd of November, she said that the deal would mean, and I quote, "Our fishermen get a fairer share of the fish in our waters." What share of the fish in our waters do our fishermen get just now, either as a percentage or as a tonnage?
Well, I mean, it's been moving, hasn't it? Because since 2012, if I take, for example, the under 10 metre fleet, in 2012 the quota since then has been realigned to deliver a 13% increase in quota for the inshore fleet, and in 2016 this generated 677.5 tonnes of additional quota. The inshore sector was allocated 1,250 tonnes of quota uplift in 2018, which equates to an extra 3 million. And indeed, it's not all, as you know, about quota, because under 10 million vessels, part of their focus is non-quota species such as crab and lobster. But the point about this is that we will be back in control, able to agree with the EU27 in the ways that countries like Iceland are able to do. And I think that is a huge win as part of the Prime Minister's deal.
Well, the point is, Secretary of State, just one other question, because we need to move on. The point is that the political declaration commits us to an agreement on quota share and continued EU access to our fishing grounds. What is the minimum acceptable share that the government would consider to be fair in the future? The Prime Minister has promised that our fishing will get a fair share of the fish in our waters. What is the red line below which the Prime Minister will refuse to accept that deal? Is there a red line?
Well, I mean, that will be a matter for the fisheries agreement with the EU, which we will aim to conclude by July 2012. And a key part of that is to have annual negotiations on access and quota share. So I'm not going to preempt those discussions. But the point about this is that we have control as an independent coastal state. We're able to negotiate on an annual basis. We're coming out of the Common Fisheries Policy, which is the policy of the SNP, and we're acting in a way that representatives from the fishing community very much welcome. And I think it comes back to my point in terms of delivering on the referendum result. People want to see us take control of our waters and this independent coastal state, and the deal that the Prime Minister has secured enables us to do so. I think that's very welcome.
Okay, Stephen. Okay. Thank you very much indeed. We've heard today that you are of the view that this vote is going to happen on the 11th of December, and you are, of course, fighting your corner valiantly for that vote to be won by the government. Let's just assume that some sort of miracle happens between now and the 11th of December and you do indeed win the vote. How long do you think it will take to turn this relatively open-ended and vague political declaration into a binding international treaty, assuming that you can start on the 30th of March?
Well, I think quite rightly a number of members of the committee have paid tribute to the negotiating team for the work that they have done in securing that political declaration, and it's slightly at odds then to dismiss it simply as vague. I think actually the wording in there is subject to significant negotiation, and actually that is an indicator of the force that it will have politically in setting the framework. Now, to the crux of your question, Mr. Kinnock, in terms of the timeframes, I would refer to Part 5 of the political declaration. That gives a clear steer as to what the aspiration. I've just referred in my answer to Mr. Grant in terms of fishing and our aspiration to have a deal concluded by July 2020. I think one of the issues as we look to the governance within Whitehall, we look at how we take this work forward. One of the issues will be to look at what the phasing of that work is. But I share your desire, or I suspect your desire, is to see momentum injected into that process. I'm very keen to see that.
So just for you to know, I mean, we've had a diverse range of witnesses giving us evidence on this issue for quite some time, and they haven't been unanimous on many things, but one thing they've been absolutely unanimous on is that the idea of turning the political declaration into an international treaty by the end of the transition phase is a pipe dream. It's not going to happen, because you've of course got the negotiation process and then ratification by 28 national parliaments and regional parliaments. So you've also, in your evidence, placed great emphasis on the need for certainty and clarity. Would you not accept that if the political declaration were amended to make a specific commitment to an off-the-shelf model, such as the Norway Plus model, that is the only way in which we'd have a chance of having this negotiated and ratified well before the end of the transition phase? Would you accept that an off-the-shelf model like that actually gives precisely the certainty and clarity and stability that the country is desperately crying out for in these turbulent times, and that you indeed have been emphasising?
No, I absolutely see the point you're driving at, but my concern is that I don't think the Norway option respects the referendum result. I think I met the Norwegian Foreign Minister last week, and I think the rule-taking element that applies in Norway would have a...
I'm very happy to have a discussion about it, but if you could just, this point about, do you accept that off-the-shelf has a chance of getting done and dusted within the transition phase? A more open-ended thing like this has no chance whatsoever of being negotiated and ratified by December 2020.
No, because firstly, one of the key achievements that the Prime Minister has made has been shifting the dialogue from this binary off-the-shelf Norway or Canada debate into something that better reflects the shared values, the close working relationships, the 40-plus years of interrelationship with Europe. And that is the bespoke model. Now, the concern I have with Norway, and I know that the colleagues across the House have raised the issue of Norway, but the difficulty there is that you continue to make payments, you continue to have freedom of movement, but also, as someone who was the Minister for Financial Services, I think there's significant issues in terms of the consequence to the financial services industry of taking rules. If you look at, for example, Lloyd's of London, if you look at, for example, building societies that have a distinct model, there are issues in terms of rule-taking, particularly in areas like financial services, that would be very welcome for the UK, much more so than they would be in the case of Norway.
If we then just look at the other scenario, which seems more likely, which is that the motion will be rejected by the House on the 11th of December, do you agree that it's the Prime Minister's moral duty as a public servant to have a plan B in place? It's a moral issue.
Well, we've covered, I think, twice now the issue of Plan B. Our commitment as a government is to win the vote. That is what everyone is focused on in government, and that is what I will be working very hard on between now and the 11th.
So if there is a compromise out there which provides the certainty that our economy and people so desperately need, and which, yes, of course, is not perfect, no solution is perfect, but it certainly provides that clarity which is so important for the commitments that we're making. Do you not think it's the Prime Minister's duty to have that option ready to go as soon as she loses the vote on the 11th?
Well, I respect the spirit in which the question is put, but my concern is that does not deliver on the referendum result, because the referendum result, for the reasons I've just alluded to in terms of the concerns with Norway, we have a deal. European Union leaders have agreed it after a very intense and difficult negotiation. The Prime Minister secured that deal in the national interest. It delivers on the referendum result for people like me on the Brexiteer side who campaigned for changes in areas like having a skilled immigration approach. It delivers on that, on fishing and agricultural on the list that we can run through. It allows us to have an independent trade policy.
But
so
if you,
significant wins there in that deal, and that's why I think it's the right deal, and we need to make that case. It's for all members of Cabinet to make that case, but we need to make the case and secure the vote. That's our priority.
On the point of the referendum and the mandate, I mean, a narrow vote to leave could very well be taken as an instruction to move house, but to stay in the same neighbourhood. Surely the instructions are to stay very close to Europe, to leave the political institutions, to leave the ever closer union, the political project, but to retain very, very close, strong and productive links through a well-established and well-understood framework. One could very easily interpret 5248 in that way. It's the Prime Minister that chose to interpret it as leaving the single market and the customs union. So we can have a long debate about what the referendum actually means. Isn't it time, though, now to put that to one side and find a pragmatic solution that can command a majority, a cross-party majority in the House of Commons in the national interest?
But I think that's exactly what's underscored the Prime Minister's approach. If you look at the fact that this is a deal that enables us to have security relationships with Europe that no other third party will have. This is a reflection of the bespoke nature of the relationship. We're not part of Schengen. The previous narrative in terms of Schengen, which Ollie we're very familiar with, is if you're not part of Schengen, you can't be part of some of the security arrangements there. Now, actually, I firmly believe this is in our mutual interest. Some of the databases, the UK puts more information onto it, as I understand it, than anyone else. So it's in both sides' interest. Both sides want to pick up if there's passengers who are a concern to law enforcement. Both parties want to ensure that we're picking up that passenger information if there's criminals moving between countries that they are identified. And the political declaration enables very close security cooperation. It enables the supply of goods to flow across the borders, but it does so in a bespoke way that also delivers on the freedom of movement, on the vast sums of money being paid, on the desire for an independent trade. And I think that's the point, that the binary choice of Norway or of Canada does not deliver what the Prime Minister's deal delivers.
Thank you very much. Welcome, Secretary of State. And one of the difficulties with this complex sort of three-element deal is the way in which it has to be reduced to sound bites for the media. So when the Prime Minister has said the deal brings back control of our borders, laws and money, while leaving the common fisheries policy and common agricultural policy and enabling us to negotiate our own trade deals, can I offer a potentially more accurate, although longer version of that, which would be to say this deal will bring back control of our borders and should do so for our laws once an agreement for life after the transition is secured and most of the 39 billion paid, although some European Court of Justice controls will remain for a while. We should be able to negotiate our own trade deals, at least on services, to the extent future agreements on our customs relationship allow. Meanwhile, this deal buys us 18 months at least to negotiate the future in detail, subject to us not being stuck in the backstop and all 27 EU governments and parliaments approving the trade and customs elements. Is there anything in that which either of you would disagree with?
So we'll just pick up the key points. So firstly, to the extent to which during the implementation period we can negotiate trade deals, that's absolutely correct. Secondly, does that give businesses security during that period, the certainty that they want? Absolutely. Does it avoid, in essence, the two-step change that many businesses want to avoid, because they want to the extent they make a change, they want to make one change? Yes, it does. On the financial settlement, that's respecting the legal obligations that the country has entered into, but it is a significant reduction on what was expected at the start of this process. Yeah. So that reflects, I think, the bespoke deal that the Prime Minister has secured, in which it gives us that independent trade policy, but it does so in a way that respects the fact that our strongest business relationship is with Europe.
Indeed. Now, I just want to check whether you were comfortable with my extension, if you like, of the sound bites that the government sometimes uses. Secretary of State, you've said several times today that this is the only deal, and you've quite rightly quoted European Union statements to support that, which would rule out the suggestion that Stephen Crabb, amongst others, have made that should Parliament not back the deal, then could the government and Prime Minister raise potential changes either to the withdrawal agreement's language on the Northern Ireland backstop or on some of the rather qualifying language in the future political declaration, for example, substituting intentions and efforts for we will do X, Y, Z. Now, the timing of this, of course, the European Council follows immediately after our vote. You're not ruling out any such effort, are you?
Well, I think, firstly, as you say, that the European leaders themselves have made clear that this is the only deal. Secondly, I think, and the Prime Minister has touched on this in one of her many marathon sessions in the Chamber, where she has been asked about whether the European leaders would reopen the deal. And I think the misunderstanding about that is that it would be reopened in a way that benefits the UK, assuming that there are not aspects of this deal, this hard-won deal, that the EU would not want to change. And we saw, I think, in the way that concerns were raised by Spain, and the Prime Minister again on Gibraltar absolutely stuck to her guns, defended our sovereignty.
I absolutely understand.
But the idea that you can reopen this without the EU 27 saying that they want further concessions, I think would be a significant risk.
I understand your point, but you're not ruling out any such effort, are you?
No, our focus is on this deal, and what I'm saying is that the EU leadership have made clear it's the only deal, but also I think the idea that after 2+ years of intense negotiation you're going to go back and get a different deal, I don't think is realistic.
Okay. Lastly then, there's been much talk, and indeed my colleague Stephen Kinnock raised the question of the option of Norway plus plus, the phrase used in the media, or really membership of the EEA and EFTA, as a possible, if not a likely, alternative should the deal not go through. For many of my constituents who voted leave, and for other colleagues whose constituencies voted leave, I think the reactions, once they realised that that arrangement would tie us into the EU's freedom of movements, oblige us to pay a considerable annual sub, lock us into the EFTA Court of Justice, which has very rarely disagreed with the ECJ, and make us a permanent rule taker, would come as rather as a surprise. What do you think you and the government can do to try and make the differences between that potential deal and the government's deal clearer before the vote on the 12th?
Well, I think you make a very good point, and I think there would be a lot of people in the country who, as I say, voted in what was our biggest ever vote, a huge democratic exercise. I think it would lead, if we were to row back on that, I think it would be very divisive for our politics. And I think it would be very damaging. And I think it's important that the government demonstrates that we are honouring the referendum result. This deal does that. And I think some of the other deals on offer would not. But also, as I referred much earlier in the session, those other deals would also need a backstop. So the idea that the reason for moving from the Prime Minister is the backstop, under those deals, there would also be a need for a backstop.
Firstly, can I just ask you some specific questions about the Joint Committee? To what extent will the Joint Committee be answerable to Parliament?
So, the Joint Committee will be formed from the Executive, so its accountability to Parliament will run through ministers in a normal way.
Yeah. So the political declaration states that the future relationship will be overseen at summit and ministerial level and also managed and supervised by the Joint Committee. So it says, looking at the extensive documents that we've been provided with, I can't see any reference to the devolved governments at all. how do they fit in terms of either direct representation or consultancy in that process of the Joint Committee's work?
Again, I think, if I may say so, that is still a matter that ministers will be keen to engage with the devolved administrations about as we go past the vote and into planning for the next phase, including for operating during the implementation period. The Joint Committee is a UK-EU body, so the representatives on it will be representatives of HM Government and of the European Union. But that doesn't preclude ministers, as they do today, from wanting to use the Joint Ministerial Committee structure and other structures that may be invented in due course to make sure that they take the full range of views into those meetings.
I think the underlying point, I think, there is a very valid one, which is how do we ensure as we move into phase 2? There have been attempts in phase 1 through, I think, the 15 meetings that David Linderton has held with Mark and Mike, respectively from Welsh and Scottish governments. My very first meeting I prioritised was to go and meet with colleagues from the devolved assemblies. But I think there is a question which is moving forward. I spoke to the Secretary of State for Wales about this very point this morning, as to how we ensure we get the balance right between, on the one hand, sharing information with the devolved governments in a way, if one takes the withdrawal agreement where it was shared, but then parliamentarians, if one's not careful, might say, well, why are you sharing it with the Welsh Government if it's not come to the House? So there's a balance to be struck there. On the other hand, I think there's a very legitimate question, which is on issues such as the Shared Prosperity Fund, which I know is a particular issue in Wales, on issues such as frictionless Holyhead and how that is picked up. How are we ensuring that the issues and the points that colleagues in Wales want to raise are actually very much part of our thinking? And that's something I'm very keen to work with colleagues from Wales on. It's something, as I say, I spoke to the Secretary of State about this morning. My very first meeting was to prioritise this because I feel it's something we need to do more of, but we need to be mindful of this balance between what we tell Parliament and what we tell the Scottish and Welsh Government. But it's something I'm very happy to discuss moving forward.
Thank you. The arrangements that are currently in place, or have been in place, have been widely criticised, and people have been worried that the Joint Ministerial Committee, for example, didn't meet for a period, I think it was, of 9 months, when there were quite crucial negotiations going on. And, in fact, the JMC has been, I think, widely seen as being not fit for purpose. I attended a meeting as a member of this committee in Cardiff recently of the forum between various heads of committees in this place and also in the Assembly and elsewhere in Scotland. And that concluded as well, we wrote to David Lidington actually about this, saying that the arrangements were not fit for purpose. So are you in a position now, or when will you be in a position to outline what sorts of arrangements will be put in place? For example, the Joint Ministerial Committee, as far as I understand, doesn't have any statutory basis, it doesn't have its own secretariat, it doesn't necessarily publish its own proceedings, etc. I mean, there are a wide range of things that it could do to establish its legitimacy. As I said, do you have plans, or are you actually implementing any plans?
Yeah, I think, as I say, firstly, I recognise the point. I think it's a very valid point. I think there's areas where it's worked well, so the withdrawal agreement bill, I think draft clauses were shared, and the feedback I have had was actually that part of the process people felt did actually work very effectively. There's other areas where I accept concerns have been raised. I think there are opportunities. So the Secretary of State, for example, has an expert panel, and I think it's important as think about how that operates, how it ensures it's working with other stakeholders. So it's advising both the UK and the Welsh Government, and I think that expert panel is one thing we should be looking at. But I'm very keen moving forward to build on the areas that have gone well, such as I say, the draft clauses. There are certain constraints because members of this House would like to feel that we're sharing information with them in the right way in terms of what is shared with the devolved assemblies, but it is something we're very happy to work with you on.
Well, I'm very keen that people do feel involved, and that the government in Wales and Scotland is involved to the extent that they can. It's just a comment really. It seems like a long chain from what the Joint Committee will be doing in terms of very important matters, and that the person on the ground then feels that through our own government and through this government and through the Joint Committee, etc. You know, it just feels like a long chain. I just wanted to ask you one other question, which has concerned me for a very long time, really. You know, if we leave without a deal and we go to a World Trade Organization sort of situation, does that inevitably mean that there's a hard border between the north of Ireland and the Republic, between Dublin and Belfast, and equally that there's a hard border between Dublin and Holyhead and Abergwaun, Fishguard? You know, that applies entirely as far as the UK, Republic of Ireland, the EU border is concerned, does it not?
Well, as alluded to a moment ago, I think one of the things I very much recognise is the importance of that trade, the Dublin to Holyhead trade, and in terms of what distortion there might be within that, and that is something that we've been discussing with the Secretary of State on that. So I think the importance of that trading link is very much appreciated, and it's something we're very keen to ensure that it is as frictionless as possible, because it is important from a Welsh perspective, and I very much recognise it.
Well, I'm concerned, you know, that there's been a great deal of attention to the situation potentially in Kent and in Dover, but as we have seen in answers to this committee, what might happen in Anglesey and in Holyhead, there seems something more of a mystery and might entail some discussions with the Welsh Government. Just lastly, you know, if you invert that and Northern Ireland does have this special deal, we might be in a position where, would we not, where Northern Ireland and the Republic has a softer border, but Holyhead to Dublin is a harder border. Is that is possibly the case?
Yeah, you don't want a situation where there's almost a distortion where there's a preference to go via Northern Ireland rather than coming across to Holyhead. So, yeah, absolutely.
I mean, that's what concerns me. And, you know, I can't, I mean, my knowledge is limited, but I can't think of any other relationship between a member states and an ex-member state, or two bodies of that sort. There are different arrangements between different parts. You know, it does seem slightly unique, and I recognise that there are unique circumstances in Northern Ireland which lead to that, but it is a peculiar situation, and I am concerned that it might lead to distortion.
Okay.
Thank you.
Thank you very much, Stephen Timms.
Thank you, Chair. Can I make a couple of questions about elements of the political declaration which touch on the services part of the economy, which, as you've emphasised, is the great bulk of it. First of all, what it says about data. The government had said it wanted an agreement on data that went beyond the normal kind of adequacy agreement. The problem with adequacy is it can be withdrawn by the EU unilaterally. The government said it wanted to go beyond that, but there's no hint of going beyond adequacy in the political declaration that's been agreed. Is it still the government's wish to go beyond adequacy, or has that aim been dropped?
So I think what the UK and Ollie want to come in, but the UK government has said is that we will unilaterally grant the EU adequacy, and the EU at this stage has said that that they would look at standard contractual clauses. So the political declaration has language on data in it, and a clear recognition of that, because from a business point of view, I think everyone recognises the importance of data flow.
The declaration is clear it wants to get on with achieving adequacy, and I recognise that, but it doesn't say anything about going beyond the normal, and I just wonder whether that is still the government's aim.
So if I can help with this, Mr. Timmins, there are two areas in which what we've agreed on data protection is extraordinary by the standards of the EU's arrangements with third countries. The first is the commitment in the political declaration, mutual commitment, but very unusual for the EU to have made this commitment to make an assessment of us before we leave the transition period. So, as you rightly said in your question, certainty in this area is extremely important for a modern economy, and the political declaration moves us a lot further forward in that respect, because we're not subject to the vagaries of the adequacy process after we leave, but that process, there is a strong commitment to undertaking that before we leave the implementation period. The second point here, and I admit freely it's a slightly more technical point, but paragraph 10 of the political declaration talks about making arrangements for appropriate cooperation between regulators, which sounds very unexciting, but what that means is that one of the things, as it sounds like you may remember about the government's proposals, was to try to make sure that the very important and deep relationship between our own ICO and the European data regulators is able to continue. And what that paragraph is doing is allowing that conversation to continue and to deepen over the next few months.
Right. I'm glad you've raised that specific point. Will the place of our Information Commissioner on the EU Data Protection Board continue beyond the 29th of March next year?
So that is not specifically provided for here, but that paragraph is an allusion to the fact that we want to continue to make that case, and the EU is listening to that case.
So does that mean, as things stand, that place will not carry on beyond the 29th of March? I'm presuming there won't be any further negotiation before the 29th of March. So, I mean, we would hope to get back on it in the future. Is that what you're saying?
Yes, I think that is the government's intention, that we would continue to participate, whether it's in the full way we do today or in a more associate way. I'm not exactly sure about now, but what that paragraph is about is allowing that conversation to develop over the next few months.
Right. So on the 30th of March, we won't have a seat on that board.
As things currently stand, we won't.
Okay, thank you. Can I just, on financial services, and Secretary of State, you made the point that you were the Minister for Financial Services, what model of financial services equivalence are we aiming for with this political declaration?
Well, I think you raised this in the House, actually, or around, because I think the concern the industry has always had is the 30-day notice and the extent to which withdrawal, therefore, would gnaw away at certainty. And I think there's, again, language in the political declaration specifically on financial services in setting quite a high aspiration, which has been agreed as to what our financial relationship should be on financial services. And I think what that speaks to is that 30-day concern and how... So the language in the text has reference to close regulatory and supervisory cooperation. That reflects the fact that actually the Bank of England, the FCA, have always been at the heart of the financial services regulatory approach within Europe. There's a huge body of expertise there that is in our mutual interest. From a financial stability perspective, it's very important that both the UK and the EU are working closely, particularly on the supervisory side. So there is language specifically in the text. Ollie will have the exact paragraph, I'm sure, to hand. But what that reflects, the substance of the point that reflects, is a concern I know you have quite understandably raised, which is the extent to which equivalence could be withdrawn.
Yeah. I mean, the Prime Minister's made the point twice, I think, in the House now, that the agreement means that equivalence won't be withdrawn on a whim. But what I'm not quite clear about is what is the basis for that confidence that it won't be withdrawn on a whim? What can we point to here that gives us confidence about that?
So just, if I may, Secretary of State, specifically here, the wording is in paragraph 39 of the declaration, where it says that is to say the cooperation on regulatory and supervisory matters should include transparency and appropriate consultation in the process of adoption, suspension and withdrawal of equivalence decisions and various other things. So that is, again, as it sounds like you may well remember, and certainly the Secretary of State will, that's an extremely unusual commitment on the EU's part, and I think it's, as the Secretary of State has said, because of that deep interconnection between the City and other UK financial institutions and the EU capital market.
And also, I think, again, in terms of some of the early discussion, Chair, we've had as to sort of the weight of the political declaration, I'd also sit that language within the wider commitments given through the G7, the G20, financial stability, the lessons to be learnt from the 2008 banking crisis. So there's a wider, I would argue, international underpinning of the desire for that to work effectively.
Can I ask, have there been specific, and my final point, have there been specific discussions between EU financial services regulators that underpin the confidence that the Prime Minister has that this won't be withdrawn on a whim? You know, is there, I can see that wording that's in the declaration could conceivably have been the result of a process of discussion with the regulators. Has it been, in fact, or is it just the negotiating team came up with those words and we'll see in the future how they can be made a reality?
Well, it's difficult because obviously I'm new in post in this role and my role in financial services, so it's probably more Ollie. But I think there were constraints on what discussions that could be had at an earlier stage. But there are in other guises with the financial stability et al. Discussions. But do you want to come in?
Very brief answer given the time. Just to say that this part of the political declaration was the product of deep expert talks between DG FISMA and a government team led by the Treasury, so it doesn't come out of nowhere. There's a process of mutual understanding here that's encapsulated in that paragraph. And on your specific point, the Governor of the Bank and the President of the ECB have been running a process together for the last few months that's been more focused on the kind of cliff edge risks, but has allowed them also to explore some of these wider issues, I believe.
That's very helpful. Thank you.
Thank you very much, Chair. Secretary of State, in the document Taking Back Control, you have the words that trade has and continues to have an overwhelmingly positive impact on prosperity, which I think is unarguable as a statement. And you've talked about how, when on leaving the EU, the UK will be free to pursue its own independent trade policy beyond the economic partnership with the EU. Now, I don't think anybody here will be seeing our relationship with the rest of the world as anything other than open and outward looking. Could I clarify whether you believe that we will be doing better outside of the EU and our EU membership in trade around the world, and how quickly do you think we'll be doing better than we currently do?
Do I think we'll be doing better? Yes, and I think that's a key part of what Liam Fox's job is about as Secretary of State for Trade. I think significant work has already gone on in terms of discussions. I think there's an appetite from partners to trade with the UK.
What evidence is there? I just quote, if I can, this may be helpful, because the Institute for Economic Affairs had done a study, and when they came and gave evidence, I asked Julie and Jessica that there could be quite a reduction in trade with our main trading partners, which are very close to us geographically, but there doesn't seem to be any clarity about how quickly we would close the trade gap with trade deals with other countries. He agreed that was a fair point. Would you have the same position?
Well, I think in terms of trends, I mean, if I quote one figure, since 2007, the UK's non-EU exports have grown from 49% of all UK exports to 56% in 2017. I alluded earlier to the primacy of financial services and services as a whole, and the opportunities that that will bring. So there are opportunities there, and a big part of the DIT's work is ensuring that we unlock them.
So it does sound like there isn't any clarity, there's no modelling that's been done that you are comfortable with as somebody who's making making a decision for the government on whether we would be doing as well as we currently do or better.
Well, I mean, that speaks back to the economic analysis that we touched on earlier, and we touched on the fact that the Prime Minister's deal is the best deal, according to the economic analysis. Within that...
The best deal, but not as good as we currently have.
Sorry?
The best deal, but not as good as we currently have.
Well, taken in isolation, and the point, as your earlier question alludes to, is the fact that actually part of the additional things that one look at is there's a whole range of other factors that would come into play on the economic analysis, demographics, global trends, migration, technology, and so forth.
Sure.
So one can't just take these things in isolation.
Well, could I ask you this question then? And I'm sorry, in the interest of time, there are over 60 countries with whom the EU has other trade agreements currently. We've been party to developing those trade agreements. Could I just understand, because I wasn't clear on this, what the position is in terms of maintaining access for British companies to doing trade under those trade agreements?
Yeah, I think that it's 40 actually. There's 40 international trade agreements covering over 70 countries. So it's 40 agreements, but it covers 70 countries, which may be just the point within it. And obviously, we're very keen to ensure that continuity. Now, if your question is precisely where are we on that, then for understandable reasons, then the progress, whilst it's been encouraging, and we're engaging regularly, they are confidential, so one can't say exactly where they are, but there's 40 actual agreements covering 70 countries, and obviously they're a key area of focus, and significant progress is being made.
Could I just add one point there, Secretary of State, which is, of course, that during the implementation period, the two parties are agreed that those third countries ought to be notified that those agreements ought to continue to apply to us as they do. So that is an additional reason why our smooth and orderly withdrawal from the European Union is ensured by this deal.
But is that a guarantee that they will continue to apply? Because they will have been negotiated on the basis of obviously 500 million plus in terms of the market of the European Union. So Mr. Robbins, I just want to clarify if your last comment is a suggestion or a confirmation that they will continue to apply.
It's confirmation that the European Union, alongside us, intends to inform third countries that they ought to interpret those agreements as continuing to apply to us for the period of the implementation period. It's not the same as a guarantee, Ms. Malhotra, but it is a strong legal view
for the period of the implementation period. So we don't know what will happen after 2020 on these 40 plus agreements covering 70 countries.
So the Secretary of State was answering that point, which is what happens after the implementation period. Apologies if it was off topic, but I was just reminding you that for the next 2 years, the important thing is that the withdrawal agreement does give us a basis on which to ensure that continuity of agreements for that period.
So it's interesting, isn't it? Because of the UK's top 50 export markets for goods that, this is according to the House of Commons Library, so you may have some slight variation on the numbers, but 10 are covered by trade agreements that are listed so far, and of the other 40 of our top 50 export markets, 18 are other EU members. Now that's quite a substantial coverage of those that we trade with, both inside and outside of the European Union. It's quite a big risk, isn't it?
Well, that's why I said earlier, significant progress is being made. There's a lot of work ongoing on that. But obviously they are confidential negotiations, so they're sensitive negotiations. But significant progress is being made.
But you want Parliament to make a decision next week on the basis of a potential future trade arrangement in the political declaration, and yet there's an intention to inform and notify third countries that they should should continue to abide by the trade agreements for the period of implementation, but no clarity at all over what's going to happen after transition.
Well, as already been covered, so there's a commonality of interest in that these are deals that have already been entered into, so these are already agreed deals. The EU is aligned with the UK in terms of the signal that it is sending, and on top of that, ministers and officials are making progress on actually concluding those. So there's a significant body of work on those, but there is a common message both from the EU and the UK on them.
It's interesting, though, I'm sorry, just last point, Chair, if I may. I mean, it almost feels a little bit kamikaze to not have that in place. I mean, what message do you want really to give to businesses? Because when you're looking at trade with other nations, you want to have greater certainty than what seems to be in play at the moment. And if you're looking at, for example, Australia, with which we might do trade agreements in the future, it's less than 2% of our trade either way between our two nations.
But these are agreements the other side has already agreed, so these are deals that they themselves want to conclude.
Just to see clarity on that, I mean, Mr. Robbins, you've explained very clearly the EU is going to notify those other parties. We'd like you to keep treating the UK as if they were in the EU for the purposes of the transition period. Presumably, the UK government has gone to every single one of them and said, can we just get assurance from you that you've read those words and you are going to treat us as a member of the EU? In other words, there isn't going to be a problem with any of those. Has that process been undertaken yet? And if so, have you had the answers that give you assurance that they will all carry on?
So that process has been hard to undertake for either party until Parliament here and the European Parliament on the European side has signalled its approval to this withdrawal agreement. So we are confident we know what the EU would say. And we're reasonably confident, though, as the Secretary of State said, these conversations by their nature are confidential, that we know how most of those third countries will respond. But it's not possible to do that formally and publicly until we have confidence that this withdrawal agreement is on its way to ratification.
But isn't that really quite a big problem, given the point that Seema Malhotra has just raised, is you're asking, Parliament is being asked to sign up to something when actually we've got no idea whether never mind future trade deals with anybody else, we've got no absolute assurance that the ones we are party to, because we have been a member of the European Union, we will continue to be party to during the transition, because it said until we voted and the Parliament's voted it's been ratified, you can't actually get an answer out of those other parties as to whether they will accept what is in the aspiration in the withdrawal agreement, the political declaration. Isn't that a rather fundamental problem?
If I may, Mr. Chairman, I think what is very fundamental is that without approval of the withdrawal agreement, and therefore us moving into that implementation period during which we are reasonably confident about the continuity of these deals, the process that the Secretary of State has been describing of making sure that in the longer term, in response to Ms Malhotra, that we are well equipped to deal with those trading relationships beyond the implementation period, we start from on the back foot.
Okay, right now, finally, because we've really got to move on now. We do have to move on. Jeremy Lafoy, sorry.
Thank you very much, Chair. Welcome, Secretary of State. Just two quick questions. One is moving on the political declaration. How this is going to be, on the assumption the withdrawal agreement is passed, this is going to be an enormous amount of work, both on the trade treaty with and other treaties with the European Union, and also on the rolling over of treaties which, or negotiation of new trade treaties which Seema has just spoken of. How well equipped are we to do that? And in fact, can we take the initiative rather than waiting for the European Union, because they will be engaged in quite a long period of political change over the next few months, so that we start off this time on the front foot?
I think it's a very good point. And I mean, firstly, the political declaration itself, in Part 5, in the timetabling it has, in the framework that it sets, obviously gives a clear direction of travel and negotiating instruction. But what underscores, I think, the question is, it is important we get the governance right within Whitehall, and that is something that we're looking at to build on the fact that, firstly, there's lessons to take from Phase 1, but also Phase 2 will be different in that, for example, we're outside the EU institutions, so that changes, for example, the Prime Minister herself in terms of her action in terms of the EU institutions and those sort of formal set pieces. So that is something that we're looking at very actively.
And secondly and finally, and I think extremely importantly, can you give, from your perspective, a vision, a fairly hard vision of where we will be in 3 to 5 years' time, and whether it will look as though we have left the European Union, and whether those broad promises that were made in terms of what we could be doing then will be fulfilled?
Yeah, very much so. I think it's very important, I think, democratically, to be able to demonstrate that. So I think the clear aspects of this agreement, such as in the skills-based immigration approach, such as in not sending vast sums of money to the EU, in having concluded international trade agreements around the world. I think fishing, farming are both issues that are often quoted, so being outside of the CAP, having our own independent fishing policy. I think these are clear ways in which this deal demonstrates to the British public that we have delivered on the referendum. But also, it is important to recognise that it's a time to bring the country back together after what's been a very divisive period of time. And as part of bringing the country back together, as part of the Prime Minister acting in the national interest in the way that she has, it's recognising the fact that we share values with our European counterparts. We're still a part of Europe, even if we're not part of the European Union, and it's important to our businesses to maintain the supply of goods, to maintain for society to maintain the security links as well, and so to have a close relationship with Europe, but one where we are sovereign and able to pursue, as I say, an independent trade policy.
Now, I think one very last follow-up, and then that's it.
Thank you, Chair. Secretary of State, I do think you'll appreciate that this is such a serious matter in terms of the clarity around the trade agreements and what that could mean for maybe businesses in your constituency as well as mine that may be doing business under those agreements. Could I ask if you could commit now to making a statement in the next week so that Parliament can be clear about the policy position in relation to these trade agreements, both during transition and after?
No, I think obviously we will keep Parliament, continue to keep Parliament informed of progress, but as I've already alluded to, partner countries would understandably view discussions as sensitive, so that has to be balanced. The point I was making to the committee as a whole is the fact that progress has been made. Ollie has already touched on in terms of the implementation period, and so we recognise the importance of the issue. Progress is being made, but they are sensitive as well.
Right, well,
that's good enough.
Both of you have been most generous with your time this afternoon, but as I said at the beginning, lots of members wanted to ask lots of questions. We're very grateful you didn't have any other meetings you needed to go to, or at least meetings you didn't tell us about, which we much appreciate, and we look forward to seeing both of you again, I'm sure, as this process unfolds, and your evidence has been very helpful. Thanks for coming. Order, order.